Why don't you go see your boyfriend?
Yeah, he's got a nice room.
You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to a party.
Hiya. Morning, Steve. Morning, Laura. I'm a bit late today. I was focusing at getting things done. And my 1 p.m. happened to fall right when I was busy sorting my things out. So sorry about that. We're gonna jump straight in because I've got dancing that we leave for 2:30, 3:34 in 4 hours time. So I don't want to waste too much time on catching up. I'm going to start us off. So there is a slight chance that when the judge comes online, he's going to remove this video. And I sincerely hope that if that happens and I am not on the tab, that it's going to jump to the next one. I'd say I'm cautiously optimistic. Right, where are we? I always get like just too far and then skip too far ahead. Oh, also, it must feel like Monday for the friends, the non-Commonwealth friends. Okay, someone said if you put autoplay on, then it is better. And turn that off. I'm going to turn subtitles on. Where did they put autoplay now? Someone said it's better for playlists. But now I can't see. Anyway. Starting with no audio on their side. Is it their side? Let's just check. Yeah. Sorry, the no audio is them, not me.
Well,
There we go.
Oh, okay.
Mr. Taylor. Court does call the case. People versus Matthew Taylor.
Yes,
Okay.
yes,
Okay, do you have a camera?
yes. Give me 1 sec.
Okay, we got you. Got you.
All right. Mr. Taylor, could you state your name for the record, please? Mr. Taylor, could you state your name for the record, please?
You need to unmute.
Matthew Taylor, I'm sorry about that.
There you go. Okay.
Your Honor, today is the date and time set for, well, the date set for the probable cause conference. Your Honor, we are respectfully requesting that this matter be set for preliminary examination at the earliest possible time. Mr. Taylor has indicated that he does have problems.
That he has what?
He has problems with transportation, and I have to let him know that for preliminary examinations, he has to be here in person. There's no negotiating that.
Okay, what I'll do, unless there's an objection, is I'd put it out a bit so that he can arrange transportation. Preliminary examination in person will be set September 24th, 2024, 9 a.m. before Judge Bar.
That's September 24th, 9 a.m. It has to be in person. So you have to arrange
Yes.
your transportation now, please.
I
You
understand.
understand that?
Yes, sir.
All
Yes, Judge.
Bond will continue.
Thank you, Mr.
And you can thank Mr. Brown for you not getting a bench warrant.
Thank you. I appreciate it.
All right, take care.
Thank you, Judge.
Thank you.
Have a good day.
You do the same. At least what's left of it for you, right? Court does call the case of People versus Elizabeth Johns.
Ready, Your Honor. For the record, Your Honor, Joe Simon on behalf of Ms. Johns, go ahead and state your name.
Elizabeth Johns.
All right.
Your Honor, we're requesting this matter be set for preliminary examination. Mr. Goldstein has filed an appearance on behalf of the complaining witness, and he will need to be present. Therefore, Mr. Goldstein is requesting that date to be October 1st.
No, you used to like it. Yes, I know. I could see it when it was about to come out, but I was hoping, please, David, don't. Did people have any problems?
No. She in fact asked for that because she wanted to be gone by the time.
Wow.
That's in there.
I know that's an. Preliminary examination, October 1st, 2024, 9 a.m. in person. That will be before Judge Freshour.
And Your Honor, I have a couple of travel requests.
When do you not? Go ahead.
My client and her family wish to travel Friday to September 2nd, this Friday, October 30th, returning September 2nd to Ohio to go to Cedar Point. And then,
Why does anybody voluntarily go to Ohio?
Yeah.
Go ahead. I'm sorry.
Good
I'm sorry.
point.
That was just my.
if it weren't Cedar Point, I don't think anyone will. But anyway,
Is there
then
anything else there? No, go ahead.
September 11th through September 19,
September 11th through 19th.
for a family trip to multi-state to Minnesota, Illinois, and Wisconsin. Extended
Minnesota, Illinois,
in Wisconsin.
and Wisconsin. Like that whole election thing. Can you write that? And that's the 11th through the 19th.
True.
Is that right? All right. That includes your dates of traveling. Yeah.
Yes.
Okay. All right. Any objection from the people? All right. I will permit the defendant to travel to Ohio August 30th through September 2nd, and states of Minnesota, Illinois, and Wisconsin, September 11th through September 19th. All right.
Thank you, Your Honor.
Thank you.
Yeah, hallway. Okay.
I'll be here all day. What? I just asked for some help. Jeez. Court calls the case, People versus Patrick Dalvin.
Ready, Your Honor. And Your Honor, Joe Simon on behalf of Mr. Dahlman. State your name, please.
Patrick Dolman.
We have reached an agreement in this matter. It's my understanding Mr. Dahlman will be pleading guilty to count 2. For resisting the obstruction charge which we dismissed. There's also an agreement that the defendant is allowed to seek that be under the prosecutor deferred at the time.
He's pleading guilty to count 2.
Correct, Your Honor.
Have him sworn.
Solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
State.
Patrick Dahlman.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
I plead guilty to disturbing the,
Yes,
I plead guilty to disturbing the peace, Your Honor.
he's asking, do you? Yes, Your Honor.
Yes, Your Honor.
All right. So now to that charge, how do you plead?
Guilty, Your Honor.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium highlighted. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of September 29th, 2023, at the location of 4100 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. And maybe Mr. Simon, you can help. What do you do at that location that makes you think that you're guilty?
Generally being loud and preventing others from having a pleasant night at the theater.
You were at a movie theater that night,
That is correct, Counsel.
and while people were in the theater, you were being loud, disruptive, yelling, making noise.
Those statements are accurate, Counsel.
And you're yelling, disturb the peace and repose of those immediate defendants.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
September 25th.
You can give me the next date.
I'm sorry.
I'm good.
September 25th, 2024, 1 p.m.
Even if I was overseas, I was gonna still say yes, I'm a bit.
That's before me. Bond will continue. Thank you.
Thank you, Your Honor. Patrick, wait outside. You right?
Court calls the case, People versus Sequel Sewell. That's it for Mr. Simon?
Don't be disappointed.
No, it's usually the Joe Simon show. It's like we go on for hours. But- All right, sir, take care.
Good afternoon, Your Honor. Erica Julian, appearing on behalf of Sequel Sewell. Will you state your name?
Sequel Sewell.
Thank you.
Yes, Your Honor. We're in the process of resolving this case. We need some additional time. Defense is requesting 3 weeks.
Without objection, probable cause, September 19th, 2024. 9 a.m. Bond continued.
Thank
Thank
you very
you.
much, Your Honor.
Thank you. Calls the case of the People versus, is it Nesta Sheena?
Natasha.
Okay, that too. William.
Yes, good afternoon, Your Honor. Robin McCoy, P63057, on behalf of Ms. Natasha Williams, who's approaching.
Your children's appearing on behalf of the people.
Well, what's your name, ma'am?
It's Natasha.
Got it.
Yes, so Your Honor, this is a probable.
Miss McCoy mispronounced it. I didn't. Go ahead. She
I like
she
what
told me
you're wearing on the
beforehand.
throat,
Just
though. Is that-
she told me beforehand. Just say it
Are
this
you
way,
wearing
Jen.
kente cloth? That looks like that's
I
okay.
am.
All right, looks nice. Okay, so This is probable cause conference. I've talked with her. We believe we received all the discovery. We're requesting preliminary exam as soon as possible.
People have their witnesses available on the 10th.
Oh, wait, so I know I said as soon as possible. What time on the 10th?
Everything gets set at 9.
9. Okay,
Will
I can
that
do
work?
that. That will work. 9 a.m.
Preliminary examination in person, September 10th, 2024, 9 a.m. That's in person before Judge Burke.
Burke, okay, and that's here.
Yes, it is.
Okay, and then she said that she's planning a trip to go to Chicago, but does not have the dates as of yet. So she's asking for permission to travel out of state. Can we email the prosecution in the
If
court?
you two can get an order together, send it in. I don't have a problem signing it.
Okay,
If both sides agree.
okay,
Or you can bring it before me, or you can bring it before Judge Burke if it's after the public exam.
okay.
All right.
All right, thank you, Your Honor. It's good seeing you.
Seeing you. Court calls the case, People versus Samantha Collins.
Good afternoon, Your Honor. Good afternoon to your staff. Hassan Hamadi on behalf of Samantha Collins. Ms. Collins, state your name for the record, please.
Samantha Collins.
Good afternoon. All right, what are we doing?
Well, we're going to be asking for another continuance of the probable cause conference.
No, go ahead.
Been a recurring theme in this case, but no, we're trying to hopefully look for a resolution if one is available. So we just need additional time. That's okay.
All right. How much more time did you guys need?
I mean, probably 3 weeks, 2 weeks.
That's a long time.
2 weeks.
He was afraid to ask for 3. I'll give him 3. Probable cause conference, September 19th, 2024, 9 a.m. as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you.
Oh, Your Honor, I would like to address bond. My apologies. I forgot.
Almost got him out of here. All right, go ahead.
Ms. Collins has been on an alcohol tether since July. She's in compliance. I will tell the court she's done everything she needs to do for the bond, and she has not had a sip of alcohol since then. We are also, asking for this because financially it's become a burden on Ms. Collins. She will do any testing that the court wants. She can, blow drop randomly for alcohol, but we're asking for the alcohol tether to be removed.
Is she, other than that testing, reporting to community corrections? Or is it just you're not
No, Your Honor.
doing that? Is there a response from the people? Council approach. A record should reflect that we've had a bench conference in this case. I'm going to grant the modification of the bond. I'm going to remove. You're on a sober link
Yeah, yes, Your Honor.
3 times a day below.
Oh, no, I don't blow at all. Sorry, I thought he was.
She's not on a sober link, just that alcohol.
Okay, so you have something around your ankle or no?
Yes,
Okay, so you're on a scram unit.
yes, Your Honor.
I'll indicate defendant may be removed from the scram unit. Okay. But if I find out, young lady, that this is the way that it works, you're still under the prohibition of no drinking. So if I find out that you've been drinking, what's going to end up happening is your bond being revoked and you'll be sitting in the Washington County Jail. And I don't think that's where you
I
want to.
want that as well.
Understood?
I understand, Your Honor. Thank you.
Well, don't thank me. Thank your counsel. He's the one that convinced me to do it.
Thank you, Judge.
All right. Thank you. Case People versus Hassan. Sorry. Huh?
There's another sound.
Oh, there's not.
I'm like, what'd you do, man? Like, wow. I should have done that before he handled that last case.
Good afternoon. Good afternoon.
Hassan, sorry.
Jessica Holland on behalf of Mr. Ansari, P8669 standing in for attorney of record George Brown.
All right. And Cesare present?
He is, Your Honor. Mr. Ansari, will you state your name for the judge, please?
Hassan Ansari.
Thank you. All right, what are we doing on this case?
Your Honor, we're requesting an adjournment of the PCC so that Mr. Brown and the prosecutor could speak regarding a resolution.
Right, and how much time are they gonna need?
We're asking for 45 days, Your Honor.
45 what?
Days, Your Honor.
That ain't happening. I think that was a legal way of saying
I think we could communicate with each other in the next 3 weeks.
that. Okay, that's what I think. Probable cause, September 19th, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor. You have a lovely day.
Thank you. Nice try, though.
Thank you.
Like a year here. Court calls the case, People versus Esmond Britt.
Ready, Your Honor. Good afternoon. Leslie Knapp appearing on behalf of the defendant Esmond Britt. Your Honor, I hope Your Honor received a letter directed to you from the Forensic Center dated August 1st, indicating they expect a report on the criminal responsibility exam within 6 weeks of that date. So I am asking if Your Honor could put this over till late September to give us time to receive and review them.
I think we were waiting on both of these to come down. I'm just trying to recall, did I make a finding on competency at this point?
We stipulated to it, I believe, Your Honor.
Note that I had is on the 25th of July, court found the defendant
Competent.
Yeah.
Okay. And the only reason I'm asking is I don't think, counsel, there was an order prepared regarding that. So counsel for defense needs to get an order to the court for that.
I'll get that done immediately, Your Honor.
And they're saying 6 weeks from August 1st.
Yes, I believe that was the date of the letter.
What do I have for mid-October?
That was
Just give me October. I got it.
7.
Okay. Why don't I just. I'll adjourn the matter to October 17th.
Thank you, Your Honor.
24, 9 a.m. As you're invited, the case bond will continue.
Thank you. You have a wonderful holiday.
You do the same.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Kandi.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Kaba Conde. Mr. Conde, can you unmute and state your name?
Kaba Conde.
I almost made it through a whole PCC date without Constantino showing up.
Oh, we couldn't let you do that.
All right. What are we doing on this case?
This is the date and time set for PCC. We're asking to have this matter set for a preliminary examination, and I do believe discovery is complete.
People have their witnesses available the 10th?
Yes, sure.
Preliminary examination in person will be set September 10th, 2024, 9 a.m. before Judge Freshour.
Thank you, Your Honor. I do
Thank you.
have a request concerning bond and a request for travel, if Your Honor would allow me to.
Go ahead.
So first, Judge, I agree with you. I don't know why anyone would ever want to go to the state of Ohio. However, my client is respectfully asking if the court would give him permission to go to Ohio. He would leave tonight and he would return Sunday, September 1st. He would be going to Legend Valley Public Campsite in Thornville, Ohio. The purpose of that would be to go camping.
Hence the campsite in the name. So he'd be leaving tonight, the 29th?
Yes,
And coming
Judge.
back when? The 1st?
Sunday, September 1st, yeah.
All right. Okay, and is that the only thing regarding bond or?
That's one thing regarding bond, Judge. The second portion of my bond request would be asking if the court would consider removal of the tether.
Response from the people.
Judge, I object to the removal of the tether. I think it's granted, we only asked for 5,000 10% by written warrant. I would ask for $100,000 bond based on the allegations. The defendant strangled the victim. He actually used his scarf to do it. She had ligature marks on her neck. She also had a bruise on her arm. He left the scene. And also, he was violating bond. We called her 4 times. 2 of the calls were after arraignment. She said, "What's gonna be different this time?" And he wouldn't answer her. So they're kind of talking about the case. So he was already in violation of the bond. I believe bond was legal to begin with.
All right. As to the modification of bond, in that respect, I'm going to deny that request. I will grant his travel request. The defendant may travel to Ohio. The
Thank you, Your
29th, that's August 29th through September 1st. Inclusive.
Thank you, Your Honor. Does the court need me
Thank you.
to send over a proposed order?
No, I think I have it.
Thank you very much.
All right, thank you.
Have a great weekend.
You do
When's
this.
the next court date?
Your next court date is
September 10th.
the 10th, September 10th in person for preliminary examination before Judge Freshoff. Let's call the case, People versus Jeff Meyer.
Good afternoon, Your Honor. Eric Lincoln on behalf of Jeff Meyer. And
Mr. Meyer, can you state your name, please, sir?
Jeff Meyer.
And what are we doing on this case?
Judge, today is the date and time set for the probable cause conference. I was told that there's a forensic interview video that was shared with me just about 20 minutes ago. I haven't had a chance to review that, so we're respectfully requesting an adjournment of the PCC, and we are prepared to waive the 21-day rule if that hasn't already been done.
Probable cause conference will be adjourned September 12th, 2024, 9 a.m. or as your invite indicates. Bond will continue.
September 12th at 9, Your Honor.
Well, I set it at 9. You'll get an invite with the actual time block you're in.
Okay, thank you, Judge.
All right, thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Kyle Stotch.
Good afternoon, Your James Mikowski appearing on behalf of Kyle Stotch, who is standing to my right.
Your name, sir? Kyle Stotch. Okay.
Your Honor, I am requesting an adjournment for a couple of different reasons.
Okay.
All right, I always have good reasons, Judge.
Yeah, I know you do.
My client, one of the charges is related to his driving privileges, and there's another attorney who's working on that with the Secretary of State. They're not going to have a decision until the end of September. In addition, I've got some ongoing discovery issues, not the fault of the prosecutor's office. I've got a PI who's working on something, and I don't have everything I need to go to exam. What I was hoping to do this is a big ask, I get it. I was hoping to either put the probable cause conference over to October 10th or set it for exam the following week or anytime after Columbus Day. I would prefer to come back here because I always like to see you and you entertain.
Buttering me up for the long adjournment. Any objection to the adjournment of the probable cause? Probable cause conference will be adjourned October 10th.
Yes.
Yes, it is. October 10th,
Thank you, Your Honor.
2024, 9 a.m. Where's your invite indicates? Bond continued. You're more than welcome.
Have a good day, Judge.
Let's call the case. The people state of Michigan versus Ali Abakur.
Good afternoon again, Your Honor. Hassan Mahdi on behalf of Ali Abu is approaching. State your name for the record, please.
Ali Abu Khader.
Right.
Your Honor, well, at this time, we're going to be asking for a preliminary examination.
Right. I will be more than happy to set a preliminary examination. Also, counsel, did you?
I did.
The modification of the bond. Deal with that.
Your Honor, I did.
Oh, you saw it. Okay. Would everybody be ready on the 10th? Or you would?
May I check my calendar, Judge?
Sure.
Yes, Your Honor.
That'll work. Preliminary examination be in person. September 10th, 2024, 9 a.m. before Judge Burke.
That time going to change or that?
No, that time is firm, that 9 a.m. time.
Thank you.
As to bond.
Your Honor, I laid it out, I think, pretty clearly in the motion. At this point, we are requesting an increase in the defendant's bond based on his non-compliance with surrendering the weapons. I have had conversations with defense counsel between yesterday and today. He has assured me that there is no AR-15 in his possession or otherwise. However, there are other registered weapons to the defendant which have yet to be surrendered. We are in the process of facilitating to have those be surrendered. However, they have not yet been surrendered.
If I may, Your Honor.
Yeah, well, I just want to clarify one thing. He wasn't on the Wayne County matter. He was not arraigned
When the offense occurred.
when this offense occurred.
Correct. It went Wayne County case, the conduct.
Okay.
Washtenaw County case conduct, Wayne County case arraignment, Washtenaw County case arraignment.
Allegedly. Conduct allegedly.
Understood.
Thank you.
But I guess what I was trying to figure out, so the magistrate in setting the bond, you believe, took into account the Wayne County conditions.
I am not certain of that. Your Honor, I is not the one who handled that arraignment or wrote the bond. So I cannot attest to what was said on the record.
I can speak to that.
Go ahead.
So this court knows Wayne County not only put him on a tether, but also home confinement. And Wayne County, obviously, through all their cases, when somebody's charged with a felony, he's not in possession of any firearms, which at that point, Mr. Abu Khader was not in possession, and to this day has never been in possession of any firearms after the bond. Now, That being said, I take full accountability for, and when I say I'm saying counsel, for him not turning in those guns, or gun, or whatever's at the home that we said to the prosecutor they're at. But he is nowhere near that home. He has to be confined to his mother's house, which he's been since day one, since he's left. What I could tell the court is we had many issues with both Washington and Wayne. Why? He has 2 tethers on his ankles, 1 on each ankle. And Washington was not going to release him because they were concerned that a tether was going to be cut off, which inevitably, after Wayne County promised they wouldn't cut it off, ended up cutting it off.
Cutting off.
The Washington County tether.
Who did?
The Wayne County Sheriff's Department. So, but then they fixed the tether, and then eventually a day later, they released him with 2 tethers. So it was a big mess. We were trying to get him out. I had discussed with my client this rifle that was, and I believe, a lethality, or one of the reports that the allegation that the victim said. He said he's not aware of that. He doesn't have that. I left it at that. It's my fault. Registered guns should have been turned over 24 hours after release. He didn't do that. We are not willing. We are going to do that. I've sent the email to the prosecutor, an email stating this is the address that they're at. If you want, Ann Arbor Police Department can come pick them up. We have no issues. We're at the court's mercy. We apologize. I know I'm talking too much, but I want you to know, Judge, it was very difficult getting him out. He definitely doesn't want to go back in. We agree he should have turned in the guns. I'm taking accountability. The guns will be turned over, or guns turned over to the Ann Arbor Police Department. Your Honor, he has not stepped foot outside of that home, other than today, actually, after he was released.
Where are the weapons?
At his sister's house in Detroit. He's confined to his mother's home in Dearborn. And another issue that this court should be aware of.
Hold it. So I thought he lived in Redford.
He lives in Detroit, which is next to Redford, correct?
Correct.
Okay, so it's actually.
I know that.
Well, no, I mean, it has a Detroit zip code.
Redford leases it to Detroit.
Okay, whatever. Redford leases it to Detroit. But anyway, so yes, it's Detroit address. 2 blocks away from that address, which currently the alleged victim actually stays at, his home in Detroit. 2 blocks away from that is his sister's home, right? He's nowhere near any of that, and he's all the way in Dearborn with his mother, where he's been since he's left the Wayne County jail. And he's confined to that home. Now, I don't want to give you my opinion.
But hold on. I'm trying to figure out, why are the weapons at his sister's house?
Well, I can approach on that end. I don't want to say that on the record, but they were not taken to his sister's house during the Wayne County or Washington County's, the Washington County case. They were not taken. They're there, Judge. That's
okay.
They were there prior.
How many weapons are we talking?
1 or 2?
Two. Is that what you have when it comes back that there are 2 weapons? I mean, I realize there's the AR.
Information from Detective DeMille at Ann Arbor is that he has 2 registered pistols to him. He also noted that the victim noted to Ann Arbor police that he either had access to an AR-15 or had an AR-15 in his possession. Detective DeMille noted that you do not legally have to or required to register an AR-15. So the fact that it is not registered does not mean that he does not have one.
Your Honor, may I approach briefly?
Yes, you may.
Thank you.
I mean, well, before you do, so here's what I'm trying to figure out. Certainly there's that condition. There may have been delays in getting him out and all those other things. I'm trying to figure out, as we speak right now, why those weapons are not in the possession of AAPD. I mean, that's what I'm trying to figure out. And I appreciate you, counsel, taking responsibility for it. But certainly the sister, if that's where they are, could have gotten those weapons and turned them over to AAPD.
She could have. But I know where I guess I know where the court is going with this.
Oh, maybe. Because I can change directions in a minute.
No, I get it. And they should have been. I don't know what to tell the court. They should have been turned over. The reality is it was a mishap, not just on, I don't want to blame him alone. It was on my end. We were more concerned about getting him out.
I understand what council's concern is in getting him out.
Yeah.
But the defendant knows he's not supposed to be, particularly given the nature of the charges, he's not supposed to be possessing any firearms.
Which he didn't.
Right. But he was also to turn those over. And I'm trying to figure out between the time of arraignment and as we sit here today, particularly given the fact that they're at this third location, why Ann Arbor PD doesn't have those weapons now.
Now you're correct. They should have been. But what I want to indicate to the court, this third location, they've been at that location before he was arraigned, before the Wayne County arraignment. That's my point.
Okay. Sorry. My point is this.
They should.
At some point, council gets the motion. At some point,
yesterday,
you two are having some conversation. I'm trying to figure out, particularly if his liberty is in jeopardy, why I don't have those guns now.
Oh, I got the motion yesterday. I wasn't even aware of this. Honestly, just kind of slipped our mind about these guns, the bond that Magistrate Fink had put about the guns being turned over. My point is, as soon as Sister Counsel sent me the email, I called her, I sent her a follow-up email, talked to my client, actually sent her a follow-up email and told her, here's where the guns are. Can you have Ann Arbor Police Department go pick them up? And that was the last that we conversed about that.
That is all correct, but I will say I am concerned because council even noted on the record earlier that Wayne County also orders as a standard condition in all of their cases, no firearms.
No,
So that would be 2 cases where he's not in compliance.
Well, I don't want to put words in my mouth. I did not say Wayne County does the same thing by saying you cannot be in possession of any firearms. Magistrate Fink actually went a step further and said you have to turn them over to Ann Arbor Police Department. Wayne County did not do that and did not ask for that, just for the record. And at that point, I didn't know he had any firearms anyway.
I want the guns. I mean, for me, that's the bottom line. I mean, I'm worried about this AR-15 issue, but it's probably more of a national phenomena that we got to kind of deal with in terms of that and the registration. So I get that. But the ones that are registered to him, I'm trying to figure out why they didn't travel with you guys or with somebody down here today to get them to Ann Arbor.
Well, Your Honor, that's another thing. And Madam Prosecutor, I guess we don't know each other, but I did come here this today early and I told her somebody would have dropped them off like before court. And then she had indicated to me she was going to confirm with the police department on whether they wanted to pick them up or I just have somebody come before we were even in front of you to drop them off. And that was the last we spoke.
And before court was after the morning docket started, so I have not had an opportunity.
To check.
Correct.
I mean, I had no problem. The email was sent yesterday, last night, if Ann Arbor Police Department wanted to pick up the guns. Your Honor, I will tell the court this. They will be
who? Okay.
They will be here today. I mean, they'll go straight to Ann Arbor Police Department right now. I'll call whoever family members can go pick them up and
I want the guns.
We're gonna get the guns too.
Oh, I know.
Oh.
And so I need confirmation that those guns, that Ann Arbor will take them. Well, I know they will. That's not gonna be a problem. If they show up at AAPD, they're gonna take them.
Right.
So I need those guns here before he leaves here. If I don't have the guns, he's not leaving.
We'll do that now.
Okay, let's go do that. I'm gonna pass the matter and let Ann Arbor know that they're on their way. You go call whoever you gotta call. They gotta get down here.
Got it. Thank you.
In recess. Be a short day. Oh, yeah, I get up. Okay, bye. Thanks, Alan. And.
I'm just trying to find when he comes back. Because I don't know if he does. Literally. We're on 8/27/32. There we go.
Court does call the case of the people versus Ali Abu
Coder.
Koder. Abu Koder. I'm trying to put the syllable in the wrong spot. Okay, counsel, state your appearance.
Good afternoon again, Your Honor. Hassan Hamadi on behalf of Ali Abu Koder. State your name, Mr.
Ali Abu Koder.
All right,
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people.
okay, and my understanding is we
don't have confirmation yet. What I will tell the court is the individual is at the Ann Arbor Police Department. I contacted the Ann Arbor Police Department to say, hey, this is the vehicle that the guns are in. That's
as far as you got.
Yep.
I am awaiting confirmation, but as far as I know, they have arrived at Ann Arbor Police. They're facilitating the turnover now.
Okay, so how many, let me ask this, how many guns came down? There was in fact an AR-15.
Yes, one AR-15 and one.
Glock 19 or Glock 40, one of them.
Well,
I was told it was a Glock 19.
Well, I don't care what you're told. I guess what registered under from the prosecutor's position, I believe there's a Glock 40 that's registered under his name. And there was a 9mm, I believe.
There are two, according to Detective Jamil from Ann Arbor,
yes,
there are two weapons that are registered to the defendant. One is a Glock 40 that was registered to him March 20th of 2020. The second is a Caltech 9 model P11 that was registered to him on April 12th of 2006.
That makes sense, Your Honor, which is actually corroborates what my client had indicated. The 6 weapon was forfeited to the Wayne County. He had at that time, a while back, he had a CCW case where they took the weapon and he never got that back. And then the 40, he did tell me he purchased a gun during COVID, which makes sense, 2020, which is the 40. But there is an AR-15 that is also in the vehicle with the 40. So a pistol, which is the 40, as well as the AR-15 is what's getting turned over. It is which all he has. Do you have any other weapons?
No.
Okay.
But didn't you say there was another one that was registered to him?
The Caltech 9, which was registered to him in 2006.
Okay, so that's the one that you're saying was forfeited.
Correct.
Okay, so there should be a Glock and an AR-15 that are turned over.
That's correct.
Okay. All right, so that everybody doesn't have to wait for this, and then forfeited. AR-15 and Glock. Some specificity. So here's what we'll do is we don't have to all wait here for confirmation. Confirmation to come through. Madam Prosecutor, if there's a problem, let counsel know. And we would set something at 1 o'clock tomorrow if that happens via Zoom. So to try to get everything straight regarding that before this proceeds on next week or in a few days for a preliminary exam.
Understood.
Okay.
I would be an idiot to ask for this, but I feel like I feel like I was going to ask for this before this whole motion was filed. And I don't know if it makes sense. I already told my client, you're on home confinement in Wayne County. and then Washtenaw County put you on home confinement. I was going to ask Wayne County to take him off of home confinement, which I have not done yet, obviously. Your Honor, don't worry about it. I strike everything I said. I'm not going to ask for a bond issue right now, especially that the court has had mercy on us and kind enough to take care of us on the weapons. You have a wonderful day.
All right, and let me just say this. Sir, your attorney's a very good attorney. And he's the only one that saved you from being locked up. I need you to understand that.
Yes, sir.
Because he represented what you told him to this court, that there was no AR-15. And there happens to be one.
Yes, Your Honor.
And it's only through the eloquence of his argument that this court is showing you any grace to not lock you up tonight, just for even making that or causing that misrepresentation to be made to me.
Thank you.
Don't thank me, you thank him. Because
Your Honor, and I do apologize.
I would.
I do apologize for that. You know, we try to be as honest as human beings as possibly, but sometimes for many reasons, you know, anyway, thank you, Your Honor.
Thank you, sir. Okay, are we finally done? Really?
I mean, let's do more. Find something.
No, let's not. For the day. I'm good, Alan. You can read that. 14A stands adjourned. I'm good, though.
Tim George, River City Attorney, is with us. The past president of the St. Joseph County Bar Association. Incoming officer, Mr. Keith Stickley, our Chief Public Defender, is here with us. I think everybody here had a wonderful Labor Day weekend. Judge Pattison is back. We're back to full staff, and I think we're ready to just get to it. Our visitors have gone back to California and Ohio. Hopefully they had safe travels. And I think they had a wonderful week to be here. Otherwise, let's see who's here. We've got Yasmin Campbell, Jennifer Moe here.
They took her for prints or something like that.
Okay, took her for prints. All right, then we've got some pre-exam conferences this morning also. Mr. Bush has got some of those. And, Mr. Ranowski and Mr. George. All right, thank you all for saying good morning. Thank you for the pictures from my friends from Cadillac. I think Elvis could have used some design help at Graceland, but anyway, thanks for the pictures. And everybody's refreshed and ready to get back to work. So let's get to it. Ms. Campbell, would you come up to the podium? Laura, I'm missing some of Miss Campbell's files. We told her if she came in this morning, we do all four of her cases at the same time. So I have only 241550 There's 1567, 1585, and 1586. I didn't want to you have to make 2 trips over here, Miss Campbell, so we sent all these all at once. Not doing too well. I got here this morning, none of my arraignments were in my queue. And they still, oh, there they are. But again, only one of your cases is in here. Now let me look elsewhere. It's going to take me a minute. I'm lacking some things that I need. Plus, I don't move too fast. Especially on the first day after a long weekend. I lost Mr. George. All right, let's see what I can figure out. 241362. No, 1550. Take a look at that one. These are all ordinance cases. You got a ticket in that case alleging that on or about August 16th, you trespassed at 185 East Michigan Avenue in my old neighborhood. Trespass is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Let's look at 1567. That is another trespass at Michigan Avenue and River Drive. That would be right at the intersection near River Glen Apartments at 3:25 a.m. Oof. The next one, 241585. Is a trespass at 3:50 a.m. 185 East Michigan Avenue near Garden Street.
When was, okay.
That was on August 26th. And then the last one, these weren't even set yet, but I had them put in with this morning because you had to be here anyway. I didn't want to make you come here twice. And the last one is another trespass. It doesn't say where, but at 3:46 a.m. on 8/26. So Mr. George, the city attorney, just walked out, and I'm going to need his help on what he wants me to do with these. And Ms. Campbell, these are not the kind of thing I normally put people in jail for, but I can't tell what's going on and why you keep going back to 185.
Oh, because I was seeing somebody that stays there and we're toxic, so now we don't no longer see each other. That's all that was. That's what that situation was, but I no longer see that person. I wouldn't even be in St. Joseph County. I live in Kalamazoo. I wouldn't even be in this county if it wasn't for court today, Your Honor.
All right. I'm missing all those other files. Did you? Oh, you didn't hear me because I wasn't on the record. I've got. They're not in my queue, and the only one I have is 1550. And I need all the rest of those. Have a seat, Miss Campbell.
Are you okay?
Now, you were living at Concord Place, but I don't think that's what?
I live there.
I think you really live here. I think you live in Three Rivers someplace.
Seems that way, doesn't it?
Yes, it does.
I guess I got more job down here than I am.
Well, my arm's not as good as it used to be, but I could throw a baseball from my house to where you were at River Drive and Michigan Avenue. So which house is that? Is it Mrs. Taylor's house?
Yes.
All right.
I was seeing one of her sons and we get into it and stuff. And long story short, like I said, we're no longer toxic, so we no longer see each other. Not been accountable.
All right. Well, let's wait for Mr. George to come back and help us. Which son? Donald?
Yes,
Donald's had a lot of problems.
I try to help him, but
Well, I told you, I saw all the Taylors at Irvin's funeral. And I had a nice chance to talk to Mrs. Taylor. But that's not a real good time to visit with somebody at their son's funeral. But like, as I said, I grew up across the street from them. Is Abel Morasco Jimenez here? I'm not doing real well. He is charged with driving without a valid cycle endorsement, and he is a white pigeon case, and he's failed to appear. And he's from Bangor. This is file 241584. OT and on the ordinance case. It'll be in my queue.
Yes.
Okay, thanks. We are off very slowly this morning. Mr. George was here. I should have held on to him. Failed to appear. We'll try and order to show cause first. Jennifer Moe, file number 241282. She called. She failed to appear once before. See if we can wake her up. Did you say she went out for prints? Maybe I should check. Hello, Deputy Hunky. Is Jennifer Moe here? All right. Yes, thank you. Bye. Keith, this is a no insurance case, and the no insurance cases are all written under state statute. And she was in front of Judge Pattison a couple of times. She had a co-file. Well, we'll see what she has for us. Now we have a couple of pretrials set for this morning. Dustin Uri, file 241361. I got an email from the White Pigeon Village attorney telling me defendant had paid his tickets and got his license back. They're dismissing the matter. Good morning. Why don't you come right up to the podium there? Are you Jennifer K. Moe?
Yes.
You got a ticket on July 23rd for driving without insurance. It's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500 and not less than $200. It's a weird statute. It's not under the motor vehicle code, it's under the insurance code. And we get a ton of these because now they can run your license plate and they can tell whether the car is insured or not. Didn't used to be able to do that. And they're 1-year misdemeanors, so they require to be fingerprinted. Because they're 1-year misdemeanors, they're all under state statute rather than city or village ordinance. This was a Honda Civic. Do you have insurance for the car now?
No, I've been actually looking since May.
What happened to the car?
It's at my house. It
All
was
right, so
impounded.
sometimes people lose them.
It was impounded and I almost did lose it.
All right, well, let's talk about that. How much did it cost you to get out of impound?
After he cut me a deal because I kept trying and trying, but because I lost my job because of the fact I lost my car, I had to scrap my son's car and borrow some money. So instead of paying the almost $2,000 that I should have paid, he only charged me $860.
Was it Kevin Roberts or was it in Sturgis?
It was Bowers and Cohen.
Okay. So the car is at your house.
Well, right now it's being hidden, but from my ex.
Now, there was a code ticket. Let's see what happened to that. No, I don't want that. Where were you working?
Through GT Independence for independent client. And I was going, the first time I got pulled over, I was going to Three Rivers to drop off lab work. Then the second time I got pulled over, I was coming back from Three Rivers from dropping off more lab work. And then since then, she's went into a nursing home.
Well, when you're in here for something else, we gave you the information about your unlicensed dog ticket. And this case, wow,
I don't have a dog.
apparently you did in
My son.
2023.
My son did.
No proof of insurance, July 18th. So just before this, you got stopped for no proof of insurance. You haven't paid that ticket. July 23rd, you got a registration plate ticket that accompanies this. And you got a registration plate ticket. So you got stopped on July 18th. And you got no proof of insurance. And improper registration. They cut you a break, and so instead of writing you for no insurance and towing your car, they gave you a civil infraction ticket. So a week later, 5 days later, on July 23rd, you got another, this time no insurance and no registration. And that no registration is a civil infraction, and you have an unpaid dog ticket. So, Keith, these are all under state statute. I don't know if Andrew's here, somebody who's supposed to be doing these pre-trials. I don't know what to do about it.
I mean, I can walk down.
Yeah.
See if they want to do something.
Um, let's see what they want to do. She has July 18th, no proof of, was it the same officer?
No, it's two different officers.
Well, the first officer cut you a break and the second officer pulled the trigger on it. I call it driving while poor. Nobody's malicious about it, but they're driving around without any insurance
My
and they
plan
gotta
is
get,
to switch to switch my car to my sister in Indiana, just so I can afford it. 'Cause without that, I can't afford it in Michigan.
I don't know how to answer that, but, anyway, then the ticket, so then you had to pay $800 to get it out of hock, which could have been used to pay for the insurance and the fines. But you don't lose the car. All right, Mr. Stickley, would you check down there and Miss Mo have a seat? And while you're at it, would you send Mr. George my way?
Yeah.
Good morning. Have you touched base with anybody yet today?
I have not heard.
You got Mr. Laffler? No, wait a minute, that's not yours. What have you got? You're just here with Keith?
Yes, yes.
Okay. I didn't know if you had one he had given you or something. All right, on this lumpy, bumpy Tuesday morning, we're going in fits and starts. As I've said several times, the caseload is quite sparse. I think due to what's going on in the change in prosecutor and the reduced staffing levels. Mr. Marvin is trying to address it. He got Andy Rognes to do some of these. And Mr. McWhale is also helping his office. I do now have, I think, the rest of Ms. Campbell's files. I think they're actually in my queue, but I need the city attorney. As I mentioned, Dustin Uri is dismissed. I have a pretrial on Jason Kolosinski and Christy Keene. Then we have felony pre-exam conferences this morning. I've had them 3 weeks in a row. My week, last week I had Judge Patterson's week, and this week we have 7 pre-exam conferences, felony cases. And several of those people are here. Don't worry about it. It'll just close on its own. All right, we are in our Tuesday morning hurry up and wait mode. Let's see, they told me that they added everything to my queue. So Campbell, let's see what else you got out there.
He hasn't yet. I don't know.
Maybe he's. I've got Vivian here.
If he doesn't, they're really wrapped up right now, but if it doesn't appear, we can,
Get an attorney to help her.
yeah.
All right. Miss Mo, why don't you come back up to the podium? Your case is complicated. There are at least two cases, 5 days apart. If you got convicted of everything, you would owe a whole bunch of money. I don't have the authority to hack it like a snowball and turn it into just one case. The prosecutor does. And we don't have a prosecutor available. One thing that you could do between now and when we go further is to get insurance. The prosecutor would be inclined to give.
I got to keep my camera on.
Just while we call the case, sir. Yeah, we're about to call it right now. Just pulling everything up, making sure we have. Yes, recording for you. Yeah,
I got to keep my camera on.
Yes, sir. Just while we call the case, sir. Yeah, we're about to call it right now. Everything, making sure we have. Yes, sir. Just while we call the case, sir. Yeah, we're about to call it right now. Yeah, I don't know if it's playing back like that. Calling case number 24004-61301FH, People State of Michigan versus Cornelius Furman. Come on.
You must have people talking.
Calling case number 24004-61301FH, on a loop. People State of Michigan versus Cornelius.
This is going well. Of course, this is the day I choose to jump in on this court. I wanted to see what that guy was, the one who was like, do I have to keep my camera on? I wanted to see what he's getting called for because it's a Michigan court. And I've never seen them live. But this isn't exactly riveting, is it? Just about to stand up and take a stretch. If you've been focusing, it's time to as well. We've been going for a bit longer than we should have, probably. In my opinion, my eyes are getting a bit.
All right, let's try this again. Mr. Berman's matter, calling case number 24004-61301FH, people of the state of Michigan versus Cornelius Furman. Parties, your appearance.
Good morning, Judge Leslie Cooper on behalf of the people, P 30857.
Good morning, Your Honor. Jacob Schwartzberg, SCHW, ARZBERG, P 37693.
301FH, people of the state of Michigan versus Cornelius Furman. I don't. Parties, your appearance.
Good morning, Judge Leslie Cooper on behalf of the people, P 30857.
Good morning, Your Honor. Jacob Schwartzberg, SCHW, ARZBERG, P 37693.
301FH, people of the state of Michigan versus Cornelius Furman. You can replay videos that have been recorded, but that you have to open a completely different program to do that. I don't have that program open, so I'm not sure what's.
That's interesting.
I'm just watching people leave the
playing on a
stream.
loop, but I don't.
Literally, like 7 people have dropped off.
That have been recorded, but that.
Nope. Sorry, Judge Giles. We can't do this. We're going back to. Well, let's hop in here.
The end of the month, so I would just ask my calendar.
And again,
Okay, in prison by
we lost you. We were in.
prior. Sorry.
Williams, I'm sorry to keep you waiting. Good morning, Mr. Flowers. Gentlemen, we're on the record in case number 24-2665 SM. Mr. Flowers, you're appearing for arraignment purposes this morning, and you're appearing with your attorney, Mr. Williams. Mr. Williams, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with your client?
I have. He will waive a formal reading and stand mute and ask the court to enter a not guilty plea.
Thank you. And you also had an opportunity to review his rights.
Yes, he understands his right.
Thank you. So the next step in the process, the pretrial conference in this case, would be scheduled for September 24th. It's at 9:30 a.m. Mr. Williams, is that date good for you?
Give me 1 second here. This case has some unique issues. Let me see here. You say the 22nd or 24th?
24th. Yes.
I have a GT jury trial scheduled that day.
Is it a full day?
I'm assuming it is because it's the only thing on the top of my calendar.
Okay.
And I wouldn't want to deal with anything else anyhow if I had a trial that day, even if it wasn't. I would be busy.
Okay. So do you think we could go to the 17th, or do you want to go the week after?
Well, here's
Thursday. Go ahead.
No, the 17th doesn't work because I have to be in Kent County right now in the afternoon. Can we just go after?
26th?
Sorry, what date?
The 26th.
We could, can I just explain a circumstance here with his situation? He,
Sure. Looks like we lost you. Me or him? Mr.
prior,
Williams.
sorry,
We lost you there for a moment, Mr. Williams. Could you repeat from the beginning of the circumstances you'd like to explain?
yeah, can you hear me now?
Yes.
So prior to this incident, he doesn't live in Michigan. I think that he lived with New Jersey. I don't remember, Luke. Is that what state?
Pittsburgh.
Pittsburgh, sorry, I knew it was east somewhere. So I guess New Jersey's not east technically. Anyhow, he got into a tragic accident. There was a death. He has to turn himself in on the 30th of September to avoid a mandatory prison sanction, but he's still going to go to prison. And he'll be in prison for probably 3 years. So even if we schedule a pretrial, he won't be available thereafter for a final status. So I'm asking in this circumstance, whatever we schedule, if we could do it by Zoom, it would be really difficult and a hardship for his family to get him back here to Michigan, to turn him back into Pittsburgh 2 days later. So he will be in prison by the time his final status comes. And so that's the circumstance. So I'm just trying to explain to you the dynamic of what we're dealing with. Is everyone there still?
Well, yes, could you put that in writing as a stip and order, please, Mr. Williams? So that the judge would be aware of the circumstances.
Yeah.
And under those circumstances, I suspect that the stip and order would be approved for a Zoom pretrial conference. And maybe final conference, or however it is that, the case is going to proceed.
Okay, yeah, then I will. Thank you. I just wanted to talk that through. I could do that.
Okay. So the 26th?
Yeah, we'll go with the earlier date. I will figure it out. I don't want him to be in a stressful situation. So
Well, let's go for the 26th. We know on the 24th that you would not be available if the trial goes. So let's do the 26th.
Do you have access to the thing? Because I don't know if this was an old case. It says Clayton Hall jury trial, GT. Do you see that? It might have been an old case that never got taken off.
Do you have the case number?
I don't. I'm sorry. It's
Oh, that's okay.
People v. Hall, it's HALL.
And again was
Clayton with a C, yeah.
I don't see anything. Are you
24th, is that?
Yes.
Yes.
September.
No, Judge Stucca has an all-day jury trial, but it's not for that case.
Then that's probably an old case then. I'm guessing that never got taken off my calendar on my end.
Okay.
It's not. Yeah.
I'm sorry to speak over you. So let's schedule it then for the 24th. That would give that extra couple days. Okay.
Thank you.
And you're welcome. Mr. Flowers, I want to verify contact information with you, please. Sir, what's your phone number?
It's 412-609-0307.
And your mailing address?
Flowers Luke 98 @gmail.com.
Where do you receive your regular mail?
Through that Gmail.
No,
Oh,
US Postal
sorry.
Service?
Sorry, yeah. 220 Sewickley.
Pennsylvania?
Yes, ma'am. Yes, Your Honor.
All right, so Mr. Williams, do you have any questions concerning bond?
I would just simply ask that he just complies with his current bond. He lives a great distance. He has no ties to Michigan. He was only here through a dating relationship that was met online. He has, no reason to come back here. And frankly, he'll be in prison here, or he'll be incarcerated awaiting a sentence to go to prison at the end of the month. So I would just ask that there be a PR bond and follow the conditions of his current bond where he resides.
Sure. So Mr. Flowers, I'm going to continue the bond with all of the same terms and conditions. I'll make sure that you understand how important it is that you're in full compliance, as these terms and conditions are in LEAN, the Law Enforcement Information Network. The court will mail you the notice regarding the date and time of the pretrial conference, and Mr. Williams, I'm certain, will be in touch with you with regard to how it is that you'll make that appearance. Mr. Williams, do you have anything further?
No, have a nice day. Thank you.
You as well. Thank you for your appearance this morning, and gentlemen, you are free to leave the meeting.
Thank you, Your Honor.
Good morning.
Morning.
Are you Mr. Farmer?
I am doing well.
Mr. Farmer, you're appearing for arraignment purposes this morning. Ms. Mistley is the defense attorney available through the Indigent Defense Council who will be assisting you in that arraignment. She's not yet had an opportunity to speak with you. So I'm going to ask to put you and Ms. Mistley in a breakout room so that she can have a private conversation with you to go over the issues regarding the arraignment, okay?
Okay.
Yes.
I don't know how to do it.
I can help you out, Mr. Alcessor.
Thank you. Yeah, I think I'm done, so.
All right. This is State of Kansas versus Katie Line, case number MGI 2024 CR 210. Would counsel please announce their appearances?
Stephanie Plashko for the state, Your Honor.
Your Honor, the defendant appears in person, apart from her counsel, Brian Rickman.
This case comes on for a review, Mr. Rickman. This is a felony case. Would you like to set this for a settlement conference or a preliminary hearing? Ms. Line's co-defendants set to appear in person this afternoon. She is represented by, let's see, I think Mr. Villa Maria. So Jim, if you want to pop on just so we can get on the same page, you're representing Ellie Line this afternoon.
Yes, Your Honor.
Do you guys want to set these for a settlement conference and attempt to negotiate a resolution first, or just set it for a preliminary hearing?
Your Honor, I have not met with Ms. Line. I spoke with her late yesterday afternoon. I was going to ask for one review so that I could go over the discovery that I have with her. I was going to meet with her after court this morning or this afternoon.
Mr. Rickman?
Judge, I have no objection to continuing this for review by Zoom in 4 weeks. Not Katie either.
Ms. Plaska, state's position?
No objection, Your Honor.
All right. Mr. Villamaria, I'll just so giving you advance notice, I'll probably set both of them for a Zoom hearing to accommodate you if you want to review in 4 weeks, okay? As well as, I think Ms. Line is, I think there's also, that's on for a motion to modify the bond conditions too. Is that correct, Mr. Rickman?
Yes, Judge.
All right, and let's take up that issue first before I reset these cases. Ms. Plaschka, have you had a chance to review Mr. Rickman's motion to modify the bond conditions? Essentially, he's asking for permission for his client to move to Missouri to live with a boyfriend. As you recall, there's a no contact order between Katie and Ellie. State's position on that request.
State wouldn't object to that. Obviously don't want to put somebody homeless. State would request GPS monitoring while she is out of our jurisdiction across state lines.
Mr. Rickman, in response?
Yeah, I think that would probably be financially a burden for her as such that she's borderline homeless if she's not able to live with her current boyfriend. We had asked that she doesn't have it yet, that she have bond supervision with court services, and she'd be permitted to call every Wednesday morning for that in lieu of an ankle monitor.
Ms. Line, do you, and I don't want the address, but you have an address in Missouri, is that correct, that you're wanting to go live? That's a yes, okay. And are you employed?
At McDonald's in Independence, but I'm gonna have to find a job over in Missouri because I can't work in Independence and then live in Missouri.
Are you reporting on bond supervision of any kind?
Yes,
All right, and how often do you report?
every week, every Wednesday.
All right. The court is going to grant Mr. Rickman's request for a modification of bond. The court's going to modify Miss Katie Line's bond conditions to allow her to live in Missouri. Miss Line, I'm going to have you provide that address of where you'll be residing to your bond supervisor. I'm also going to add a condition. Well, I guess if it's already in place, I'm going to remind you of your condition to report to your bond supervisor as your bond supervisor directs. I'm not going to make an order that you appear via telephone. I'm going to leave that up to your bond supervisor. If they'll allow you to do that, then that's up to them. If they want you to come in, you'll have to make accommodations. Do you understand that?
Yes, sir.
Okay. Ms. Line, your next court date is going to be October 1st, 2024 at 9 a.m. via Zoom. That'll be on for a review / select preliminary hearing date.
Okay.
All right. Anything further in Ms. Line's case, counsel?
Not from the state, Your Honor.
None by defense.
All right, Ms. Line, I'll see you October 1st. Thank you.
Thank you.
All right, Ms. Garcia, are you available? Or Ms. Jones? All right, this is State of Kansas versus Lindsay Garcia. Case number MGI 2024 CR 66. Would counsel please announce their appearances?
Stephanie Plaschka for the state, Your Honor.
Your Honor, Miss Lindsay Garcia appears a person apart from her counsel, Brian Rickman.
This case comes on for a diversion review. Mr. Rickman, what's the status of diversion for Ms. Garcia?
Judge, I believe this will go diversion. If we can continue this for another 4 weeks, I mailed a diversion application to Miss Garcia last week, and I need to set up time to meet with her. I know right now she's working for UPS, I believe, or some of those different delivery companies, and she has a pretty busy schedule. But I think we can get this diversion submitted application in the next 2 weeks. And
I'm off today, so I can come in and meet you today.
okay, Lindsay, if you could come to the courthouse about 1:30 today, we could do that.
I can do that.
Okay.
Ms. Plaschka, state's position.
No objection, Your Honor.
Ms. Garcia has done an excellent job of appearing via Zoom every time she's had this, has been on for review. So the court is inclined to continue this to October 1st, 2024 at 9 a.m. for another diversion review. Ms. Garcia, the quicker you can get in and out with Mr. Rickman regarding the diversion review and sign it, the quicker we can move your case forward, okay?
Okay.
All right, October 1st, 9 a.m. via Zoom. Thank you, Ms.
Thanks,
Garcia.
sir.
All right, Ms. Jones, are you there? Kimberly Jones?
Or I've not had any contact.
She's on now.
Oh, she is? Okay.
Yeah, this is State of Kansas versus Kimberly Jones, case number MGI 2024 CR 64. Would council please announce their appearances?
Stephanie Plaschka for the state, Your Honor.
Your Honor, Ms. Jones appears by Zoom apart from Counsel Brian Rickman.
This case comes on for review. Go ahead, Mr. Rickman.
I would like to set these for a settlement conference on October the 1st at 1. I would ask that Ms. Jones can come up here around 11 o'clock that morning, or perhaps we can speak by phone because she does live in Muskogee, Oklahoma.
Okay. Ms. Jones, or I guess Ms. Plaschka, state's position on a settlement conference, would that be beneficial for the case?
Yes, Your Honor.
All right. Ms. Jones, I'm going to set your next court date as an in-person hearing in Independence on October 1st, 2024 at 1 p.m. All right, you'll need to be up here. Mr. Rickman's request that you should...
Sorry, I'm sorry.
Okay, no problem. It's going to be Tuesday, October 1st, 2024 at 1 p.m. in Independence, Kansas. That's going to be on for a settlement conference in person. So you'll be here with your attorney, Mr. Rickman, and a representative of the state will be here, and you'll discuss the case and see if there's a resolution to be had. And if not, we'll make arrangements for a preliminary hearing or some other type of hearing that Mr. Rickman and the state want to set this case for. You understand that?
Yes, sir.
All right. I would advise you to come up a little bit early to meet with Mr. Rickman, maybe around 11. He'll be available to meet with you to discuss the case before your settlement conference, okay?
Okay.
All right.
Judge, may I give Ms. Jones my phone number so she can call me? I don't have a phone number for her in my file.
Absolutely. Ms. Jones, do you have a pen?
Yes, sir.
All right, go ahead, Mr. Rickman.
Ms. Jones, my phone number is 620-331-4329, and my extension is 212.
Okay.
Okay, and you're my last client on the docket this morning, so if you would kindly call me back here in about 5 minutes, I will visit with you briefly and get your phone number, all right?
Okay.
All right, thank you.
All right, Ms. Jones, we'll be in recess till October 1st. I'll see you then. Thank you. Thank you, Mr. Rickman.
Yeah, I will mute my audio here.
Sure. Let's see. All right. Tracy, do we have anyone here on the court laptop computer?
Yes, Your Honor, I have two that do not have attorneys, Mr. Hawkins and Mr. Shepherd.
Amber Dabney is here, Mr. Villamaria. I'll let her in.
Thank you, Judge.
I don't see Mr. Barlow yet. Amber Dabney, if you start your audio video. You are Amber Dabney?
Yes.
All right. This is State of Kansas versus Amber Dabney, case number MGI 2023 CR 162 and MGI 2024 CR 270. State of Kansas appears by and through Stephanie Plaschka on both cases. In the 23 CR 162 case, Ms. Dabney appears in person via Zoom with her attorney, Mr. Villamaria. That case is on for review. Ms. Dabney, additionally, a new case has been filed, 24 CR 270, and that case is on for a formal first appearance. I am going to go over with you the charges, and then we'll talk about representation and next court dates from there, okay? Ms. Dabney, you have been, a complaint information has been filed on August 13th, 2024, alleging 3 counts. I'm going to read to you those counts and ask if you understand them, not whether or not you agree or disagree, but just if you understand what you're being charged with. You understand that? All right. Count 1 alleges that on or about August 11th, 2024 in Montgomery County, Kansas, that you, Amber Dabney, did unlawfully, feloniously, and knowingly obstruct, resist, or oppose a person authorized to serve process, to wit, John Anderson, and the discharge of any official duty. In this case, service of a felony arrest warrant, and that act the act of the offender substantially hindered or increased the burden of the officer. Interference with the law enforcement officer is a severity level 9 non-person felony with a penalty range of a minimum of 5 months to a maximum of 17 months in prison and or a fine up to $100,000. You understand that?
Yes.
Count 2 is alleging possession of marijuana, that on or about August 11th, 2024 in Montgomery County, Kansas, that you, Amber Dabney, did unlawfully and knowingly possess a quantity of marijuana. That is a severity level, or is a class B non-person misdemeanor with a penalty range of up to 6 months in the county jail and or a fine up to $1,000. Do you understand that count?
Yes.
Count 3 alleges possession of drug paraphernalia, that on or about August 11th, 2024 in Montgomery County, Kansas, that you, Amber Dabney, did unlawfully use or possess with intent to use drug paraphernalia, to wit, a plastic baggie used or intended for unlawful use in storing, containing, concealing, injecting, ingesting, inhaling, or otherwise introducing a controlled substance into the human body. Possession of drug paraphernalia is a class B non-person misdemeanor with a penalty range of up to 6 months in the county jail and or a fine up to $1,000. Do you understand that count?
Yes.
All right, Ms. Dabney, if you want to have an attorney represent you on these charges, I'm going to need you to fill out another financial affidavit, okay?
Okay.
You know that financial affidavit that you filled out before Mr. Villamaria was appointed to represent you?
Mhm.
You'll need to fill another one of those out, okay?
Okay.
Has anything, preliminarily, has anything changed in your employment since the last time you filled out a financial affidavit?
No, I've been looking for work though.
Yeah.
So,
The court is going to tentatively appoint Jim Villamaria to represent you in 24 CR 270. Mr. Villamaria, would you like to pass both these cases so you can have a chance to review the allegations in that 24 CR 270?
I would, Your Honor, yes.
Do you want that set for a review via Zoom or in-person settlement conference?
Your Honor, let's do it at in-person settlement conference.
October 1st?
Yes.
All right, Ms. Plaschke, does that work for the state?
Yes, Your Honor.
All right, Ms. Dabney, your next court date is going to be in person on October 1st, 2024 at 1 p.m. in Independence. That'll be on for a settlement conference in both cases.
okay, October 1st at 1 p.m.
Yeah, it's Tuesday. Before you leave, just a second, Mr. Newton has popped on my screen. Yes, Mr. Newton.
Judge, Dan left me a note that Ms. Dabney needs to report for bond and complete a intake with us.
Okay, does she usually meet on Wednesdays? What time does she usually?
Wednesday between 9 and 11 is when Dan has everyone reporting.
Okay. Ms. Dabney, you're going to be ordered to report to Mr. Driscoll this Wednesday between 9 and 11. Is that correct, Mr. Newton?
Yes.
All right. To do an intake. That's going to be in Independence. Do you understand that?
Okay.
This Wednesday is going to be tomorrow, so September 4th.
All right.
All right, and if you don't, I'm going to have Mr. Newton or Mr. Driscoll inform the court, and I'll suspend your bond for failing to abide by court order. Do you understand that, Ms. Dabney?
Yes.
All right, but assuming all things go well, you report tomorrow as instructed. I'll see you on October 1st in person, okay?
All right.
Thank you, Ms. Dabney. Yes, sir.
One last.
Yeah.
Amber, if you would call 620.
Okay.
235.
Okay.
1806. That's my office number. Leave a message. I will call you back probably tomorrow.
All right. I'll do that.
Thank you, Amber.
All right. Bye.
Thank you, Ms. Dabney.
Thank you.
Mr. Villamaria, I'm inclined to call Mr. Barlow's case. Is that okay?
That's fine, Your Honor. Yes.
This is State of Kansas versus William Barlow, case number MGI 2024 CR 115 and MGI 2024 CR 214. Will counsel please announce their appearances?
Stephanie Plaschke for the state, Your Honor.
Your Honor, Mr. Barlow appears not, but through counsel James Villamaria, who appears via Zoom.
These cases come on for a review. Ms. Plashka, Mr. Barlow has done a good job of appearing for his court dates and now has recently been approved for court-appointed counsel services. I'm sure Mr. Villamaria has not had a chance to meet with Mr. Barlow as of yet, as he's recently appointed. State's position?
Your Honor, state would allow this defendant to appear on Thursday before requesting a bench warrant.
And I'm inclined to agree with you. Mr. Villamaria, the court is going to order a bench warrant for Mr. Barlow for failure to appear, but the court will not execute that bench warrant until the conclusion of the Thursday afternoon docket. So if Mr. Barlow wants to appear this afternoon or on Thursday, we can get his cases set and the court will withdraw that bench warrant. But I'll execute.
Your Honor, if court services or Mr. Newton has a telephone number, if they could email me that telephone number. I don't have any contact numbers for Mr. Barlow. If he's, I'm assuming he's on bond supervision.
He is, and Dan says that he has been reporting. I can check his file and see if we have a phone number for him.
If you would, and then just email me the number, Nick, that'd be great.
I can do that.
Okay, thank you. Thank you, Judge.
No problem. Thank you, Mr. Villamaria.
So, what day again, Judge? October 1 at 1:30. But
for Mr. Barlow?
Yeah, for Mr. Barlow.
Well, I have a bench. There's a bench warrant for failure to appear, and I'm not,
Right.
and I won't execute that bench warrant until the conclusion of this September 5th afternoon docket.
Okay.
So if he appears, we'll reset his case.
Okay.
I'll probably do the October 1 date, but
Okay.
I'm hesitant to set it right now because there's a bench warrant that's going to be pending.
Okay.
Okay.
Okay. Thank you, Judge.
Thank you, Mr. Villamaria. I appreciate it.
All right. See you this afternoon.
Mhm. Morning, Mr. House. How are you?
Good morning, Judge. Just fine.
Mr. Freeman's in the waiting room. I'm letting him in right now.
All right, thank you.
Mr. Freeman, if you start your audio video. Travis Freeman, if you'd start your audio video. You are Travis Freeman?
Yes, sir.
All right, am I pronouncing that first name correctly, Travis?
Yes, sir.
All right, this is State of Kansas versus Travis Freeman, case number MGI 2023 CR 300039. Will counsel please announce their appearances?
Stephanie Plashka for the state, Your Honor.
Gary House for the defendant, Your Honor.
Thank you very much. Before we proceed in that case, Mr. Freeman, in the Coffeyville Police Department case 24-309, the state of Kansas has declined to prosecute at this time. So
Okay.
what that means is that you are not being, any bond conditions that are attached to the 24-309 case will be released. However, you still have a pending case, 23 CR 300039, that is still active, and any conditions in that case are still active. Do you understand that?
Yes, but what does the second case pertain to?
Well, that was a case that was, and that's I'm sorry, Cherryville Police Department case, not Coffeyville. I apologize. That was a case that was alleging a violation of protection order and a possession of hallucinogenic drug. The state is just declining to prosecute at this time. That doesn't mean the state cannot bring charges at a later date. You can discuss the statute of limitations with Mr. House regarding that case. But we're going to proceed today on the 23 CR 300039 case. And that case is on for a review or select preliminary hearing date. Mr. House, how do you want to proceed in Mr. Freeman's case?
Your Honor, this is a case that was transferred from Judge Cullen's docket, as the court knows. And I had reached a tentative plea agreement with Mr. Gayoso, who is the assistant county attorney handling that case. I need to talk with Ms. Plaschka about it. But I'm pretty confident that we will arrive at a plea agreement. If the court would set this for a plea hearing on October the 1st,
Sure.
I can get a plea petition prepared and make sure that it's approved
All right.
by Ms. Plaschka.
All right. Ms. Plaschka, is the state comfortable with October 1 at 1:30 p.m.?
Yes, Your Honor. And Mr. House, I did respond to your email.
All right. Mr. Freeman, you're going to be ordered to appear in person on Tuesday, October 1st, 2024 at 1:30 p.m. That's going to be on for a plea hearing.
Yes, sir.
All right. That'll be in Independence, Kansas. Anything further in Mr. Freeman's case, counsel?
Not from the state, Your Honor.
No, Your Honor.
All right, Mr. Freeman, I'll see you October 1.
Thank you.
Thank you, Mr. House.
Thank you, Judge.
All right, let's take up the individuals that are in custody. Well, I guess Shelby Hines is not in custody anymore. Do you have a Matthew Violet, Deputy Kuba?
Your Honor. Yes, Your Honor. Here's Matthew Violet. Hello, sir.
Mr. Freeman here, I'll help you get out of here.
Yeah, I can't get out.
No
I'm
problem.
sorry.
I got you. It's no problem. You are Matthew Violet?
Yes, sir.
All right. This is State of Kansas versus Matthew Violet, case number MGI 2024 CR 287. State of Kansas appears by and through Assistant County Attorney Stephanie Plaschka. Mr. Violet appears in person in custody via the Department of Corrections laptop computer. Mr. Violet, a complaint information has been filed alleging 9 counts. I'm going to read to you those counts and ask if you understand what they are, not whether or not you agree or disagree. Do you understand that?
Yes, sir.
All right. Count 1 is alleging burglary. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully, feloniously, and without authority enter into or remain within a building which was not a dwelling, to wit, a detached garage at 507 Independence Avenue, Cherryville, Kansas, with the intent to commit a felony, to commit a theft therein. Burglary is a severity level 7 non-person felony with a penalty range of a minimum of 11 months to a maximum of 34 months in prison and or a fine up to $100,000. To understand that count?
Yes, sir.
Count 2 is aggravated battery. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully, feloniously, and knowingly cause bodily harm to another person, to wit, Dwayne Bush, with a deadly weapon, to wit, a stone statue, or in any manner whereby great bodily harm, disfigurement, or death could have been inflicted. Aggravated battery is a severity level 7 person felony with a penalty range of a minimum of 11 months to a maximum of 34 months in prison and or a fine up to $100,000. You understand that count?
Yes.
Count 3 alleges criminal damage to property. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did feloniously and knowingly by means other than fire or explosive, damage, destroy, deface, or substantially impair the use of property, to wit, a garage door, to the extent of at least $1,000 but less than $25,000 in which another person had an interest, to wit, Dwayne Bush, without the consent of such person. Criminal damage to property is a severity level 9 non-person felony with a penalty range of a minimum of 5 to a maximum of 17 months in prison and or a fine up to $100,000. Do you understand that count?
Yes, sir.
Count 4 alleges misdemeanor theft. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully obtain or exert unauthorized control over property or services, to wit, 2 tires and a leaf blower, with the intent to permanently deprive the owner, Dwayne Bush, of the possession, use, or benefit of the property or services with a value less than $1,500. Theft is a Class A non-person misdemeanor with a penalty range of up to 1 year in the county jail and up to a $2,500 fine. Do you understand that count?
Yes, sir.
Count 5 is alleging interference with law enforcement officer. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully and knowingly obstruct, resist, or oppose a person authorized by law to serve process, to wit, Charles Joseph Anthony Allen and/or Zachary Farmer, in the discharge of any official duty, to wit, resisted arrest and fought with deputies. Interference with a law enforcement officer is a Class A non-person misdemeanor with a penalty range of up to 1 year in the county jail and/or a fine up to $1,500. Do you understand that count?
Yes,
Sorry,
sir.
the fine is $2,500, excuse me. Count 6 is battery on law enforcement officer. That's alleging battery on law enforcement officer. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully and knowingly cause physical contact with another person, to wit, Zachary Farmer, a uniformed or properly identified county law enforcement officer, other than a state correctional officer or employee, a city or county correctional officer or employee, or a juvenile detention facility officer or employee, while such officer is engaged in the performance of such officer's duty, and the physical contact was done in a rude, insulting, or angry manner. Battery on a law enforcement officer is a Class A person misdemeanor, a Class A person misdemeanor, with a penalty range of up to 1 year in the county jail and/or a fine up to $2,500. Do you understand that count?
Yes, sir.
Count 7 alleges DUI. That on or about August 25th in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully operate or attempt to operate a vehicle within the state while sustaining an alcohol concentration of at least 0.08 grams of alcohol. Driving under the influence is a Class B non-person misdemeanor with a penalty range of not less than 48 consecutive hours, nor more than 6 months in the county jail, and a fine not less than $750, but not more than $1,000. Do you understand that count?
Yes, sir.
Count 8 is alleging transportation of an open container. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully transport in a vehicle upon a highway or street an alcohol beverage, meaning an alcoholic liquor or cereal malt beverage, in an open container, not in the original unopened package or container, the seal of which had not been broken, and from the original cap, cork, or other means of closure had not been removed, nor in the locked rear trunk or rear compartment of any locked outside compartment, which was not accessible to any person in the vehicle while it was in motion. Transportation of an open container is a unclassified non-person misdemeanor with a fine punishable by a fine of not more than $200 or imprisonment of not more than 6 months. Do you understand that count?
Yes, sir.
And count 9 is alleging illegal registration. That on or about August 25th, 2024 in Montgomery County, Kansas, that you, Matthew Violet, did unlawfully display or cause or permit to be displayed or have in possession any registration receipt, certificate of title, registration license plate, registration decal, accessible parking placard, or accessible parking identification card, knowing the same to be fictitious or to have been canceled, revoked, or suspended or altered. This is listed as an unclassified misdemeanor with a penalty range of a fine not exceeding $2,500 or imprisonment in the county jail of not less than 30 days, no more than 6 months of imprisonment. Do you understand that
Yes, sir.
allegation, Mr. Violet? Okay.
Yes, sir.
This case has been assigned to Judge Gettler. So your next court date is going to be September 24th, 2024 at 9 a.m. That'll be on for an attorney review. Mr. Violet, regarding representation, you can hire an attorney to represent you at any point. If you feel as though you cannot afford an attorney, you'll need to fill out a financial affidavit that the deputy will provide to you. The court will review that, and if you meet the financial qualifications, the court will appoint an attorney to represent you. But you must fill out that paperwork in order to be considered for court-appointed counsel services. Okay? Anything further, Mr. Violet?
Yes, sir. I was wondering if I could ask for a bond reduction or an OR bonds today, please, so I can get back to work.
Well, Judge Gettler set your bond at $7,500 cash professional surety with bond supervision and no contact with the victim or witnesses. The court believes that's an appropriate bond, so I'm going to deny your request at this time. If you wish, you can renew that request for a modification of bond with Judge Gettler on September 24th, okay?
Okay,
Thank you, Mr. Violet.
thank you.
This is in the District Court of Butler County, Kansas, case entitled City of El Dorado Plaintiff versus Clinton E. Rogers Defendant. It's case number in the District Court 2024 CR 365. Rob Lane appears as prosecuting attorney for the City of El Dorado. David Miller appears as defense counsel. Clint Rogers, the defendant, appears separately from his lawyer by Zoom. This matter comes before the court at this time for first appearance in district court following appeal out of municipal court. Is there any announcement to be made regarding case disposition at this time?
No, Your Honor. There probably is an issue that we would need to take up on the notice of appeal. It was filed beyond the 14 days, and I'd filed a motion to allow that appeal out of time.
Is that motion contested by the city, Mr. Lane?
Yes, Your Honor, but I would imagine an oral argument would be sufficient. I mean, I don't know that it would need to take up a lot of time.
All right. I understand the defendant's position here from the motion that was filed. What is the city's position?
Your Honor, the city will stipulate that the municipal court obviously is not a court of record, and that Ortiz, the case law cited by the defendant in this case, is on point with regard to the specific 3 exceptions as far as allowing an appeal to be filed out of time and thus to perfect, I guess, the jurisdiction with the district court. The defendant argues, I believe, in his motion that there's no specific enumeration, I guess, of the defendant's appeal rights. While the city will stipulate that there's not a specific enumeration of the rights afforded to the defendant, there is a notation in there that does indicate that the defendant was advised of the appeals process. It was handwritten by the city judge in this particular case, and it's the defendant's burden to show that he wasn't made aware of his rights. The case law is replete, I guess, with basically language that kind of groups or refers to it together, and nowhere does it require a specific written out delineation, I guess, for lack of a better phrase, of the various rights. In this particular case, there is, I think maybe it was asserted that there was, the only thing we can look to is the trial disposition sheet, and I would agree with that because there is no record, but it's the defendant's burden to show that he wasn't aware, and there's no affidavit here indicating that he wasn't advised of his appellate rights, swearing to that, because it just isn't true. We have a very experienced municipal judge. I think Judge Baker's the judge in 4 jurisdictions now, if I'm not mistaken, at least. Been doing the city court work for a long time, and does specifically advise all defendants of their appeals rights, and specifically the 14 days in general. While I'll acknowledge that that wasn't written out, so to speak, the appeals process was written out. And I think the defendant is trying to shift the burden here to have the city prove something that we can't prove either, because there is no record. And so I think that the appeal should be dismissed for lacking jurisdiction.
Mr. Miller, your reply?
Sure, Your Honor. Thank you. And I cited to the court State versus Patton. I think it's on page 2 of my motion. And the last paragraph, and I agree, the burden is on Mr. Rogers in this instance, but the court says the evidentiary burden of showing that the district judge failed to communicate one or more of these 3 pieces of information. That is, you have the right to appeal, you have 14 days, and you have the right to appointed counsel if you cannot afford an attorney. You look to that information at sentencing. The burden's on the defendant, who must demonstrate deficiency from the transcript of the sentencing hearing. So I think Patton essentially says you look to the record and see if those three items of the first Ortiz exception was communicated to the defendant. And the record, as Mr. Lane indicates here, and I agree, the only record we have is the record of the journal entry or the judgment entry from the municipal court. While I agree, and I recognize that in my motion, it says notified of appeal process. That does not delineate the three requirements of the first Ortiz exception. And so I would argue that the court is to look at the record. In this case, the record is the judgment entry, and on its face, the judgment entry is deficient. And that's why we would request the court to allow that the notice of appeal to be filed at a time under the first Ortiz exception.
All right, anything further along these lines, Mr. Lane?
No, nothing other than Judge, I think we're in a lot of on the same line here, but nothing requires it to be delineated. That's not a requirement in any of the cases. So that's the only addition to have.
All right. This court recognizes that Mr. Lane very well may be correct. Judge Baker, being the experienced municipal judge that she is, specifically notated on the trial disposition report that the defendant in this case was notified of the appeal process. What her notification was, though, is not clear. Perhaps the city's form should just simply lay out all of the Ortiz factors, if you will, and therefore the disposition record itself would inform this defendant of his appeal rights. I don't know exactly what Judge Baker said. Judge Baker is not here, obviously, to testify. This court must presuppose then that the notification of the appeal process might just simply have been, you do have a right to appeal this decision to the district court, which would be insufficient under Ortiz. With the lack of a record to demonstrate with certainty that this defendant was properly notified of his appeal rights, this court must construe the notation of being inadequate under the circumstances. The court will allow the filing out of time under the Ortiz exception. All right, we have this matter now in district court, the court allowing the filing out of time. Where do we need to go from here, counsel? Is this case going to get worked out or not?
Well, Judge, honestly, I had not had really an opportunity to talk to Mr. Lane about possible dispositions. If he's open to that, if the court would want to do maybe set a status report, and I could talk to him about it.
Okay.
And,
well,
and
here's the thing, counsel. I've got a setting in October for jury trial beginning.
Okay.
Monday, October 7th, about a month from now. That is specifically designed for cases of this nature. It's a Butler County docket, and it's relatively short that week because of judicial conference, which the court's required to go to. So Monday, October 7th, I'm going to set this case for jury trial.
Okay.
Your Honor, I'm out of the office the 7th, 8th, and 9th.
For personal reasons, professional
Yes,
conflict?
I'm sorry. Yes, personal reasons. I apologize.
All right. I'll defer to that, Mr. Lane. I really don't want to delay this.
Yeah, Judge, I think I would have 2 witnesses, maybe 3. None of them would take very long as far as direct examination.
Right. My next setting for Butler would be Tuesday, December the 3rd.
Judge, could I check real quick my calendar?
I am available, Your Honor, on December 3rd, and I would imagine we may need the 4th if it spills into that, and I can do both those days.
All right.
Judge, but I have a murder trial starting December 2nd here in Sedgwick County.
Presuming it goes.
It is a firm date. I've been told by the judge there's gonna be no more continuances, so. It's Judge Williams here in Sedgwick County. Sorry.
Judge, our next jury trial date would be January 7th.
That is if I went into 2025, which I will not.
Okay.
Thank you, though. Rather, I think I'm going to set this case as an alternate to my Greenwood Elk settings, starting Tuesday, November the 5th.
I can do that, Your Honor. I can only do the 5th and 6th. If 2 days is all I can do, but
I can't imagine this case would take 3 days, Mr.
I
Allen.
agree.
Tuesday, November 5.
I would be available too, Judge, sorry.
All right. Again, this case is set as alternate to Greenwood Elk matters that are set for the same time period for Tuesday, November 5, spilling over into November 6 as necessary. We will set a pretrial conference the week before.
Judge, I'm assuming that jury trial, that's in person, is that correct?
Oh, it is. It is.
And then
11 o'clock a.m., council. You must fully participate by video and audio means at that time. Friday, November 1, 11 o'clock a.m. Jury trial in person currently set. Tuesday, November 5, Wednesday, November 6. And counsel, if this trial goes, I'm going to need by noon on Monday, November 4th, any proposed instructions. Certainly just pick numbers. If you're using pick, those need to be provided to my office and to my assistant by noon on Monday, November 4th at the latest. We will have conducted our pretrial conference and we'll know our trial status on Friday.
Yes, sir.
Yes, Your Honor.
Okay. Mr. Lane, are you aware of anything else that needs to be addressed at this time in this Clinton Rogers matter?
No, Your Honor, thank you.
Mr. Miller, anything further at this time?
No, Your Honor, thank you.
Mr. Rogers, I trust you've been able to see and hear everything adequately this morning?
Yes, Your Honor.
All right, very well. Then the next setting in the case is 11 o'clock a.m., Friday, November 1, for pretrial conference by Zoom. Have a good morning, gentlemen.
Good morning. This is State of Kansas versus Jet Hazelwood, case number 21 CR 20. Counsel state their appearances, please.
May it please the court, the state appears by Jill Gillette, County Attorney.
This is exactly what I was worried about. Don't worry, I've got another thing to watch. Ah!
Is independent of all those things. So to play a whack-a-mole of get this man in here for 1 day for testimony, it deprives Alfred and the other co-defendants and co-counsels
through Saturday. And I spent 2 weeks convalescing afterwards. And in conjunction with that, on July 23rd, I had a medical procedure and I spent a week convalescing after that. Also, my mother passed at the end of June, and a few weeks before that and a few weeks after.
Sorry, I'm gonna switch to this judge. And switch my view up because that Judge Boyd one, you need context.
Ms. Vachon.
I'm sorry, what was that?
Can you hear me and see me? And can you also hear and see Melissa Vachon, your attorney?
Yes.
Okay, this is an arraignment, Ms. Sweeney, on a bench warrant, which was issued for your arrest because you failed to appear for a sobriety court review hearing back on August 7th, which you were ordered to do so. Anything on the failure to appear, Ms. Vachon?
Not at this time, Your Honor.
Okay, so Ms. Sweeney, you have now been appeared before the court, albeit not voluntarily. And so the bench warrant is canceled and your bond is revoked. And I'm going to set you for a probation violation arraignment where we have many alleged violations that we need to address with you. That hearing will be tomorrow. And that will be September 4th at 2 p.m. Anything further, Ms. Vachon?
No, Your Honor.
Okay, and Ms. Sweeney, that'll be via Zoom tomorrow. So you'll be at the jail and we'll get a Polycom set up for you to be seen by the court via Zoom. Okay, Ms. Sweeney, did you hear what I just said?
Yes, ma'am.
Okay, that's all for this record. Thank you. Thank you very much. Kevin, Julian, Harry, Anderson. And good morning. We're here on the record this morning in the matter of the people of the state of Michigan versus Kevin, Julian, Harry, Anderson, Mallet, case number 24541 SM. This is the date and time set for an arraignment. May I have your appearance for the record, please?
Yes, Your Honor. Melissa Vachon on behalf of Mr. Anderson Mallet while he appears separately by video.
Thank you very much. Good morning, Mr. Anderson Mallet.
Hi.
Are you able to
morning.
hear and see me and Ms. Vachon?
Yes, I am.
This is an arraignment, and the purpose of this hearing is for me to inform you of the charges against you, the maximum possible penalties, and all of your rights. You're charged in this misdemeanor complaint in count 1 with the crime of malicious destruction of personal property in an amount of $200 or more, but less than $1,000. This is a misdemeanor punishable by up to 1 year in jail and or $2,000 or 3 times the amount of any destruction or injury, whichever is greater. In counts 2 and 3, you're charged with the crimes of domestic violence, and these are punishable by up to 93 days and or $500. A consecutive sentence may be imposed under state law if the assault was committed in a place of confinement. Sir, do you understand these charges and the maximum possible penalty?
Yes, I do.
You have a right to an attorney. If you can't afford an attorney, one will be provided for you at public expense. Ms. Vachon, is Mr. Anderson Mallet making an application to your office?
Yes, Your Honor.
And he also has a right to a trial. Ms. Vachon, have you reviewed the trial rights with your client?
Yes, Your Honor. We will enter not guilty plea.
And so we're setting this for a pre-trial on September 25th at 9:30. Final pre-trial October 11th at 9:30. Jury selection October 15th at 1 p.m. Ms. Vachon, did you and Mr. Anderson Mallet discuss his living situation?
Yes, Your Honor. He does not live with the complaining witness.
So does he have a new address?
It's the apartment on Deer Path.
Okay, well, that's my information where the victim is living.
No, she doesn't stay there. She,
My understanding, Your Honor, she has a separate address, and she does not stay with him anymore.
Okay, well, I appreciate your understanding and of course, Mr. Anderson Mallett's information, but that's not what the court can go on. I would need that to be confirmed through the assistant prosecutor with the victim. So does he have another address or do we need to, what are we gonna do today, Ms. Vachon?
I did not speak with him about that, Your Honor, but I know he has family in the area he could stay with potentially. Is that
Okay.
right, Mr. Anderson?
Me?
Mr. Anderson, do you have another address, an alternative address to the 1320 Deer Path?
Yes.
Okay, and what is that address?
The 3018 Cooley Drive, that's Lansing, Michigan.
3018
Cooley Drive.
A is an apple?
Yeah. What A?
An 8.
The number. Yeah.
The number
sorry.
8, 3018 Cooley Drive, Lansing, Michigan,
4891.
4891
1.
1. Okay.
Also, I have another one where my daughter is like staying with my auntie right now, but like
Okay.
I don't know her address.
Well, Mr. Anderson, I need if you want to be released today, I need a solid address where you will be living while this case is pending.
Yeah, 3018.
That has been provided. Ms. Vachon, with that, would you like to be heard on bond?
Yes, Your Honor. I would request a personal recognizance bond for Mr. Anderson Mallett. He informed me that he has a lot of ties to the area. He has full custody of his 9-year-old daughter. He's also working 2 jobs. We discussed a no contact order and he won't have any problem complying with that, Your Honor. He is presumed innocent at this time, so I would request a PR bond.
Okay. Did you and Mr. Anderson Mallett discuss his criminal history at all?
Yes, Your Honor.
Okay. Mr. Anderson Mallett, did you may not have known about some warrants? Ms. Vachon, are you aware of those?
I believe there is a pending case in Southfield.
Okay, and then another one in Lansing?
No, Your Honor, I don't think he's aware of that.
Okay, okay. Mr. Anderson Mallett, did you hear what Ms. Vachon and I were talking about?
Yes.
Okay, so when I make a bond determination, I have to consider 2 main factors, and one is will the person appear for court? You have a warrant out of another jurisdiction for failing to appear. So I have evidence and reason to believe that you may not appear for your court dates, which is troubling to this court.
I definitely will.
What was that?
I definitely appear, especially having custody of my daughter. I'm not trying to lose, and like I'm trying to get everything situated like as much as possible.
Okay, well, I'm just going off of the information I have before me, and that's you didn't appear for a different court. So that's something I must note. I also need to consider, are you a threat to public safety? And these are assaultive offenses. You have other offenses that are assaultive in nature and your criminal history, unfortunately. So there are concerns there. So what I'm saying to you, sir, is that while you have a presumptive right to a PR bond, the court could only do that in these circumstances if I'm fully convinced that you will comply with all of your bond conditions. And the most important condition will be you will not be able to have any contact with the complainant in this matter, whose name is Amaria Dowdell. And when I say no contact, that means any type of contact, including going to the address at 1320 Deer Path Lane, apartment 32. Mr. Anderson Mallett, do you understand the significance and weight of that bond condition?
Yes, I do.
And will we have any issues with that bond condition?
No, we won't.
Sir, your bond is set at $1,000 personal recognizance. You're subject to the following conditions. You must appear as directed. You may not leave the state of Michigan without permission of this court. You must not commit any crime while you are on bond to this court. You must not have any contact with an individual named Amaria Simone Dodell. And it's Amari Simone Samone, last name Dowdell. When I say no contact, that means contact by any means or mode. You may not call her, you may not text her, you can't contact her on social media, you can't be within her physical presence, and you may not have a third party, such as a mutual friend or family member, contact her on your behalf. If you do any of those things, your bond will be forfeited. You'll be subject to additional bond conditions and arrest without a warrant. You also may not enter into 1320 Deer Path Lane, apartment 32 in the city of East Lansing. If you violate that condition, it'll subject you to immediate arrest without a warrant, and I guarantee your bond will be forfeited and you will be held in custody pending this case. I think we need to have, let me see, I'm seeing if there's a fingerprint order here, Ms. Bashan. Yes, I'm signing an order for you to have your fingerprints taken. Maybe that has been done at the jail today. And I'm updating the address that you provided. If that address changes for any reason, you have to notify the court immediately. Understood?
Yes, and so I'm not sure, like, am I gonna be released or I have to bond out?
So this is a personal bond, personal recognizance bond, which means that you do not have to pay any bail at this time. I'm releasing you because you have given me your word and assurance that you will come to court as ordered and you will comply with my bond conditions.
Okay, thank you, ma'am.
Ms. Bashan, anything further from you?
No, Your Honor.
Okay, that's all for this case.
Ms. Bashan.
Matter of Discover Bank versus Brian Ronikowski, case number 24-2079 GC, date and time set for a motion hearing. May I have appearances, please, for the record?
Yes, Panayotis Marcellus, P number 66572 on behalf of Discover Bank.
Thank you very much. And Mr. Ronikowski, hello to you.
Hi there.
Are you both
Is
able
it-
to hear and see me okay?
Yep.
Yes, Your
Okay,
Honor.
excellent. I know you met in a breakout room. Any updates for the court?
Yes, Your Honor. Basically, Your Honor, we've decided that that the plaintiff is entitled to a full money judgment, and there's be no interest if it's paid within 2 years, and then otherwise interest will accrue.
Okay, so it sounds like the parties have come to a consent judgment.
Mhm. Yes, Your Honor.
Okay, Mr. Ronikowski, did you hear what the attorney told me?
Yes,
And is that all accurate?
yes.
Okay, so, sir, do we want to place the terms on the record, or will you be filing like a consent with all the terms signed by Mr. Ronikowski?
It all depends on Your Honor. Mr. Ronikowski, do you want us to email you the consent judgment? You can sign off on it.
Sure.
Okay, great. And then, Mr. Rogen, I'm sorry, Rodenkowski, can you give me your email address?
Sure. It is B NN
and
IE
at gmail.com. And a phone number just in case.
313
I'm sorry, 313
727
7473. WRONNIE@gmail.com.
Correct.
Okay, great. And then I'll get a consent judgment, Your Honor.
Okay, very good. And that'll be filed through my file?
Yes.
Okay, excellent. Mr. Ronankowski, do you, as an unrepresented party, do you have any questions for the court about what's happening today or what you're doing? You know, we're here for a motion. We could go forward with that motion, but instead, what I'm hearing is the parties came to a resolution by which you are agreeing that you owe the plaintiff the full amount of that judgment. And then the plaintiff is saying if Mr. Ronankowski pays within 2 years, we're not going to assess statutory interest.
Correct. Yeah, the one question I had is, you said when we talked in the pretrial conference, there was something about if I got everything paid by the specific time or whatever, that I forget if you call it, I forget the wording you use, but it wouldn't be on my like permanent record or whatever. It wouldn't be is that accurate or is that not?
So there's another type of resolution called a conditional dismissal. And that would happen, and that is not what I'm hearing today. This is called a consent judgment.
Okay.
So a conditional dismissal, again, you know, that would be more likely where someone pays the amount before we get to, you know, the hearing or the trial or whatever it is, and then the plaintiff agrees to dismiss.
I understand.
Yes. One thing that I'm sure the plaintiff's attorney, you know, will know and can speak to you about is if this is a satisfied judgment, which I think I can see that you intend to satisfy this judgment and pay in full. They can file a satisfaction of judgment, and that then goes on your record, and that's a very positive thing. So then again, when we talk about creditors or we talk about, you know, anyone you're trying to lease from, they may see that judgment, but they'll see the satisfaction of judgment that has been filed.
I understand. Thank you.
Absolutely. So look for your email. And what you need to review that document, make sure all the amounts and everything is just what you have agreed to. And then if you give, you'll sign it or give permission to sign it, and then the attorney will submit it to the court.
Sounds good.
Okay. Anything else from plaintiff?
No, Your Honor. Thank you so much.
Okay. That's all for this case. Good luck, Mr. Ronankowski.
Thank you.
Thank you.
Thank you.
On the record in the matter of Waterfront Apartments versus Gray Bentley, Vicky Bentley, and all other occupants, case number 242716 LT. This is the date and time set for a second hearing. May I have appearances, please, for the record?
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Waterfront Apartments.
Thank you, Mr. Whitty. And we have Gray Bentley. Good morning, Gray.
Good morning.
And then we also have Vicky Bentley on your phone. Vicky Bentley, if you could unmute, please.
Good morning.
Good morning. There you go. So this is a second hearing, but at the first hearing, Vicky Bentley did not appear. So at this point, Mr. Whitty, and I'm going to advise her of her rights, and then we can move forward. Miss Bentley, you're a named defendant in this landlord-tenant proceeding, and as such, you have certain rights, including the right to hire an attorney. If you can't afford an attorney, it's possible you would qualify for free legal services. I have a local legal aid agency phone number I could give you if you would like it.
No, thank you.
Okay, and you also have a right to have a trial in this matter. If you want to have a trial, jury trial, you would need to tell me now and pay the appropriate jury fee. Do you understand your right to a jury trial?
I do understand.
And you have a right to know it's possible you will qualify for renter's assistance, and there are agencies and information that should have been provided to you and is available on the court's website of possible funding sources. Do you have any questions about those services?
I don't. Thank you.
Okay, you're welcome. And then finally, you have a right to know it's possible that you could come to an agreement with the landlord. That would mean that this case would be dismissed. Do you understand? It's called a conditional dismissal. Any
Yes,
questions
I
about that?
understand. I do.
Okay, very good. And then Gray, those rights all continue for you. You remember us talking about those rights last time?
I do, yes.
Okay, Mr. Whitty, I know you spoke with both defendants. How are we proceeding today?
Your Honor, I'm pleased to report the parties have agreed to a conditional dismissal in this case. If I could put those terms on the record.
Go ahead, thank you.
There's currently rent to retain due in the amount of $4,052.49. Court costs are $187.63. Total amount to retain $4,240.12. We've agreed that it sounds like Ms. Bentley is just getting some financial aid squared away and that this should be able to be cleared up. So she's going to pay $2,700 by September 6th and the balance of $1,540.12 by September 13th. We discussed that partial payment wouldn't stay issuance of a writ, that if she didn't make the payments as agreed, we could come back without further notice or hearing, get a judgment and an order of eviction. We also discussed her rights under MCR 4.201J, after which I asked both defendants if I had their permission to sign on their behalf. They both gave me their email addresses and indicated that I did have that permission, which I'd like to confirm on the record.
Thank you, Mr. Whitty. I'm now addressing both Gray and Vicky. Did you both hear what Mr. Whitty just told me?
Yes.
We did, yes.
Okay, and Gray, is that all accurate according to your understanding?
It is, yes.
And Vicky, is that accurate as well to you?
Yes.
Okay, so I just want to go over the essential terms. The amount that you are agreeing that you owe is $4,240.12 to be paid $2,700 by this Friday, September 6th, and the balance to be paid the following Friday on September 13th. Gray, is that your understanding of the agreement?
That is, yes.
And Vicky?
Yes.
Okay, and Gray, do you understand that partial payment, so anything less than those full amounts that we talked about, will not stop Mr. Whitty, the landlord, from coming back to court and asking for an order evicting you? Do you understand that?
I understand, yes.
And similarly, Vicky, do you understand that as well?
Yes, I do.
Okay, and I understand that you and Mr. Whitty spoke about your rights under the court rule because you're unrepresented and you don't have a lawyer appearing for you today, that you have 3 days from the date that I will sign this conditional dismissal to review the document, to make sure it's exactly what you agreed to on the record today. And if there were any misunderstandings, you could come back to me within 3 days, ask me to review it, and possibly set it aside. Gray, do you understand that right?
I understand, yes.
And Vicky, do you understand that right?
Yes.
Okay, and did you both give Mr. Whitty permission to sign the order of conditional dismissal on your behalf for you? Gray, did you give permission?
I did, yes.
And Vicky, did you also give Mr. Whitty permission?
Yes.
Okay, so the court is satisfied that the defendants, Vicky and Gray Bentley, understand their rights and are voluntarily waiving those, and that the dismissal here is fair and just under the circumstances. So Mr. Whitty, you'll be submitting that via my file. Is that correct?
That's correct, Your Honor. Thank you.
Okay, very good. Gray, anything further from you today?
No, I don't believe so.
Okay, Vicky, anything further from you?
No, thank you.
Okay, that's all for this case. Good luck to you both.
So you should get a reminder for the next court date, okay?
Thank you.
Okay, thank you. You are free to sign out of Zoom. Okay. Now calling case number 17W004157. This is the Township of Ypsilanti versus Simone Smith. Can I have appearances for the record, please? Ms. Smith, can you unmute and state your name for the record? Can you hear me?
Yes, can you hear me?
Yes. Can you please say your name for the record?
Yes, sorry about that. My name is Simone Smith.
Okay, thank you. So today is the date and time set for a show cause hearing in this matter. What I am seeing is that you were last in front of me on April 30th of this year. You had a balance then that was $504. Your balance is still $504. What's going on?
Okay, thank you. I tried to, I don't know, I know you can see me, but I tried to pay it online. I have $100. And the last time we talked, I was dealing with my mom and things like that. And I thank you for you saying that it was on good faith. My mom passed. I dealt with that. And I scrounged up to get the $100. My daughter, I'm sick, but my daughter is going to bring it in today. I thought I could just do it like the Zoom and, pay online, but it wouldn't let me. So I apologize for that.
Okay. So first, I do want to say my condolences on the loss of your mother.
Yes, ma'am.
Okay. So what I am going to do is set another court date. That will be.
Thank you.
You're welcome. A Wednesday afternoon, October 2nd. So about a month. Okay. Wednesday, October 2nd, 2024. That will be at 1:30 in the afternoon.
Perfect.
Okay. That will be over Zoom in front of me.
Okay.
Okay.
Yes, ma'am.
And so long as the balance goes down, you'll be in good shape. Okay.
Yes, ma'am.
Okay.
I just need to thank you again because it's been so long and I don't even remember what it's for.
I cannot hear you. You got real quiet.
I wanted to thank you for it's been a long. You've been so patient.
Okay. I appreciate what you're trying to say. Your connection is not great. Getting real quiet, sort of fading out.
Okay.
So I do appreciate what you're trying to say. I do
Yes,
offer
ma'am.
my condolences. I will see you again in a month. And as I said, so long as you're making a good faith effort to pay it down, you'll be in good shape. Okay?
Yes, ma'am.
Okay. Thank you very much. You are free to sign out of Zoom if you don't have any questions for me.
No, ma'am, I don't. Thank you and have a good day.
Okay, thank you. You too. Now calling case number 20W001170R. This is the Township of Ypsilanti versus Chanika Williams. Can I have you state your name for the record, please?
Chanika Williams.
Okay, thank you. So today's the date and time set for a show cause hearing in this matter. What I am seeing is that you were in front of me on April 30th. You had a balance of $210 on April 30th. Your balance is still $210. So what's going on?
Yes, ma'am. The last time I spoke with you, you told me that I would be able to fill out the financial hardship form online, which I definitely did that. And I received an email not until July 22nd in regards to them setting me up a payment plan. So they did set up a payment plan for me. They told me my payment plan wouldn't start until August 1st of $10 a month. And on August 6th, I sent out, they were supposed to send me something in the mail according to the email that I received for me to make my payments. I did not receive that, so I did call and speak with a clerk at the courthouse, and she told me that I couldn't make them online because it was a payment plan and they only accept full payments online. So she advised me that since I did not receive the paperwork, to just send it in a money order. So on August 6th, I did send a money order of $20 directly to the courthouse.
Do see this. Can you hear
On August 6th.
on August 6th? Okay.
Yes. Yes, ma'am. On August 6th.
And you
Yes,
mailed
ma'am.
you mailed it to the 14B District Court?
Yes, ma'am.
Okay. Did you put your name or your case number on it?
Yes, ma'am. I did everything the clerk told me to do as far as mailing it out.
Stub from the top?
Um,
I don't need you to find it right now.
okay.
But yeah, no, don't worry about finding it right now. But I am checking to see if they've gotten the money order. Okay.
Okay.
So I'm checking with the clerks. They're going to check the fact that you mailed it August 6th and there hasn't been a payment applied. Concerns me that we didn't receive it. So if you still have the stub, you should be able to use that for them to potentially track it to see
Okay.
what happened, but I don't know.
That's why I was a little scarce about it, because the email said that they were going to send me like this payment sheet, I guess,
Okay.
to send it out with it, but I never got it. And when I asked the clerk about it, she said that she didn't really know about that. I guess that's a different system when we do the financial hardship form. I'm not sure, but
Um,
because she was saying she didn't even see my payment plan at all. So I had to go back through my email to give her the information off of my email.
okay. So see if you can find the stub. You may end up
Yes.
having to cancel the money order and try again. You may want to bring something into the court. I'm continuing to check with the clerks. But at this time, what I am going to do is set another court date so that we can check in with you on this.
Okay.
Okay, in about a month. And then, assuming at that point that we're having payments make it to the courthouse and that following the payment plan, then we'll set the next date further out. Okay. So, what I will do is set this for Wednesday, October 2nd,
Mhm.
2024. That will be at 1:30 in the afternoon over Zoom in front of me. Okay?
Okay. Yes, ma'am.
But yeah, check into the money order on your end. We're checking into it on ours as well. Okay?
Okay. Cool.
Okay, thank you then. And do you have any other questions for me right now?
No, ma'am.
Okay. Okay, then you are free to sign out of Zoom. Your hearing is concluded.
Thank you so much.
Thank you. Okay, Mr. Roberts. Now calling case numbers 19W007420, also calling 23W001477R. These are the Township of Ypsilanti versus Anthony Lorenzo Roberts. Can you
Yeah,
please?
I'm here.
Thank you. State your name for the record.
Anthony Roberts.
Okay, thank you. So what I am seeing is that you were last in front of me on April 30th. Your balance at that time was $406. It is still $406.
Yeah, I was in the process of moving. I honestly forgot track of this recent court date to have it paid before. I had just got the text message yesterday, the notification. I do apologize. I totally forgot about it. I was asking, could you at least give me till New Year's? I can have this balance paid in full by then.
So what I will do is set you for another show cause hearing in November.
Okay.
Okay. So that, because presumably you can make some sort of payment on this between.
Yeah, I can at least have half of it, if not all of it, paid by then.
Okay, so then that is what we will do. So long as the balance is not $406, you will be in good shape. Okay.
Sound like a plan.
Hmm.
I said that sound like a plan.
Okay, thank you. So your next court date will be November 19th, 2024. That will be at 9 a.m. over Zoom in front of me.
Okay.
Okay, and then as I said, so long as the balance has gone down,
Yeah.
you will be in good shape.
Okay.
Okay, so November 19th, 9 a.m. Do you have any questions?
No, I do not. Thank you
Okay.
very much. I appreciate it.
Well, thank you. And like I said, so long as the balance is lower, you'll be in good shape. We will see you in November, unless we don't have to, because if it's paid in full by then that court date will be canceled.
Okay.
Okay.
All
Thank
right.
you.
Yeah,
And you're
thank
free
you.
to sign up.
Have a good day.
Okay, so I'm just hopping in here because I'm jumping around a lot, but I basically have about an hour left before I have to head to dancing. I don't know what's going on with my fringe. I've been focusing. And I love watching Magistrate Brayley, but it's easier when I've edited all the pauses out. So I'm going to jump to this one because otherwise we're all going to get bored. There has not been any sign of Judge Simpson so far. I don't know if he's just not streaming today. I don't know what the situation is, but last Tuesday he also didn't.
And what are we doing with Mr. Dent today?
Your Honor, this is a negotiated plea other than I'm asking for there to be no stay away. He is transferring to Georgia State University, and those are student apartments. This incident happened more than 2 years ago. So I'm just asking for no stay away so that, in case he's placed at that location for his housing, he can stay there. And I guess we may need to change it to no violent contact with these complaining with or victims.
Mr. Rhodes?
Yes, is it my understanding you're saying that he's a student at Georgia State right now?
Well, he's transferring to Georgia State. So he will be.
All right, Your Honor. What I would just ask is that once that transfer is complete, then the state would have no issue with him receiving housing at the 120 Piedmont Avenue address. But since he is not currently a student, that it remains a stay away at this time.
Oh, we just like Georgia State this time. I transfer next fall.
Next fall, yes.
That's fine.
Okay, all right.
When does he plan on beginning his class work, Mr. Ty?
In the fall. He's currently a student at
Gordon State.
But he's transferring in the fall.
Okay, so the fall is like pretty much this month. So he's gonna be there this month?
Next fall.
Next fall, so a year from now. Okay, so hopefully a year from now, this will all be completed.
It'll be a once, Your Honor.
Right, exactly. So, all right, so so it is a negotiated plea?
Yes, Your Honor, and I'm asking for the probation to go non-reporting. Oh, yeah, sorry, it's a negotiated plea. That's already there.
Okay, all right. Good morning, Mr. Dent. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Would you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Mr. Rhodes?
Yes, Your Honor, very briefly, as it relates to position number 9 and 10, on position number 9, count 1, the state is recommending 12 months to serve 20 days. He needs to receive credit for 10 days. He's already served. Stay away from the 120 Piedmont Avenue Northeast, apartment 2509 in particular in Atlanta, Georgia. No further contact with Daniela Shonye. I'm going to try to spell that. It's Showynye. Count 2, 12 months probation. I'm sorry, 12 months to serve 20 days, credit for time served 10 days. The balance on probation. Stay away from the same location. And this time, no further contact with the victim, JC Sloan. He is to undergo an 8-week anger awareness, anger management course. And after completing the 8-week anger management course, probation will terminate upon completion. And the two are to run concurrent, Your Honor. Thank you.
Hi.
Yes, that's our understanding, Your Honor. He's entering a guilty plea and we stipulate.
Mr. Dennis, my understanding that in case 23 CR 001309G, you wish to plead guilty to disorderly conduct and simple battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
All right, we're gonna go on the record and say, I realize you were not expecting to be here, so your address is excused, that's fine. So we're going on the record in 2024 CR 0735, State of Texas versus Claudia Aaron. Could I have the parties announced for the record for the state?
Daniel Hanson Walker, the state of Texas.
Defense.
Christian Vega for the defense.
All right, you're here for a bond?
Yes, Your Honor. Elizabeth Russell, attorney of record, had filed a motion to set bond.
Well, let me ask you this, because previously I had the attorney of record as Jody Sawyer. Has she filed a motion to withdraw?
I believe there was a motion to withdraw, and then Elizabeth filed into the case.
Well, no, I mean, has it been signed?
That is my understanding, Judge. I don't know if that's what reflects on.
All right, so we'll need to find if that's done, because if that has not been done, then Jody Sawyer is still the attorney. So let's figure that out first.
Yes, Judge.
And I'll see if I can look up on my system.
You see if that's on us. Good to see you.
You too.
Yeah, showing that Elizabeth is the attorney of record. Judge, it's okay if I sit.
Yes, it's okay.
Okay. Judge, Elizabeth Russell was appointed on July 17th.
No, but she may have been appointed, but her retained attorney was Jody Sawyers. So unless Jody Sawyer's filed a motion to withdraw, then she is still the attorney. And unless that motion to withdraw was signed, she's still the attorney. So my question is, has a motion to withdraw been signed? If not, she's the attorney. And you're saying that Elizabeth Russell was appointed?
Yes, I believe after that motion was granted.
All right, so the first question is whether or not that motion was granted. Because if that motion has not been granted, then that is her attorney.
Okay.
All right, so what I do know from my memory, what I do know is that Ms. Sawyers at first wanted to be withdrawn from the case because she said she was having issues with Miss Aaron's father interfering with her ability to represent her. However, that motion was never signed because where we left off was the father gave Miss Aaron's medical records. And then after that, Miss Sawyers never asked that the motion to withdraw be heard again. So Miss Sawyers is her attorney. And if somebody has appointed attorney, then that's interfering and that's unethical to appoint an attorney when she has a hired attorney.
I think that might be the confusion here, Judge. It seems like the dates where she filed this motion on 7/2, and then Elizabeth Russell was appointed after that without any substitution. So
And there can't be a substitution when an attorney has been retained and managed assigned counsel. I'm assuming managed assigned counsel appointed somebody, or?
I'm not sure, Judge.
All right, so then Jody Sawyers is the attorney of record.
Okay.
So if you want to get in touch with Jody Sawyers and
Yes,
have
see what I
her
can
here,
do.
and then somebody else needs to find out if she's retaining a counsel, then how is she qualified for a court-appointed attorney? Those are issues that need to be addressed unless we're just giving everybody a court-appointed attorney, whether or not they can afford one.
I'll look into
These are
that.
just questions the court has.
I understand, Judge, and I can look into that for efficiency. Mr. Escobar has indicated that, he'll defer to your judgment on this issue of whether or not she's.
Oh, state's attorney will need to be here.
Okay.
All right.
All right.
Okay, so I'll be here all day.
Okay, Judge. Good, Judge.
So if you all want to get in touch with Jody Sawyer, you can.
We will. Thank you, Judge.
Okay, you're good.
See what the shows are. Is it Associate Judge?
All right, thank you.
Yeah, thank you. Got most of the stuff moved, so.
I'm sorry, what?
I got most of my stuff moved, it's just, water fell on my foot right as I was.
Oh,
moving the
wow,
box.
awesome.
Yeah, so, yeah, horrible pain.
Well, let me just tell you, LSU lost, Florida lost, but hey, we still can pick things up.
Exactly. Alright, Judge, see you later.
All right, thank you. Is there anything you need?
Yes, Judge, if I could approach.
Yes.
Your Honor, I have a voucher, old voucher. I don't know what happened, why it wasn't paid before. So I redid it and they said it's past the date to talk to you.
You
So,
can talk to me. I think when people are appointed to represent people, they should be paid.
yeah, thank you, Judge. I agree with that.
I have no idea why this wasn't.
They just said, talk to you, get you to sign it and they'll pay.
Oh, sure.
So, thank you, Judge.
And I'll put on here, I think they still won't do it unless you put extraordinary circumstances.
Oh, okay. Thank you, Judge. I appreciate it.
You're welcome. I've been there.
Know how it is. It's good. Yeah, it's good when someone has been through the same problem.
All right, if you'll give that to them in the back.
Yeah, well, they said e-file it or something like that. So,
Oh, they are doing that now, but
Yeah.
you need to make sure that clerk doesn't have to sign off on it.
okay, I'll do
All right.
that then. Thank you,
Thank you.
Judge.
You're
Thanks for your help.
How was your?
Good morning.
Your Honor.
Good morning, Mr. Zaney. How are you?
Well, how are you?
Fine, thank you.
How was your weekend?
Uneventful. Yours?
I had hosted a bunch of 11-year-olds, so it was not. I went to bed early on Sunday.
I'm sure ring led by a particular redheaded 11-year-old.
Oh yes, you know.
Yes, and
Yep,
good times were had by all.
they were.
Wow. All right, so we are on the record in the matter of People versus Lowell v. Workman. This is case 24-0531-OD, and may I have appearances for the record, please?
Yes, Your Honor. Good morning, Edward Zaney, on behalf of Mr. Workman. He's present to my right, appearing via Zoom with consent.
Thank you. Good morning, Mr. Workman. How are you, sir?
Good morning. How are you?
Fine, thank you. All right, so Mr. Workman, we are here for an arraignment, and I call arraignments the worst case scenario hearing. Here's why. I am going to read the charges against you with the maximum possible penalties, and you aren't going to be allowed to say anything. Reason for that, you are innocent. You are innocent in the eyes of the law, and the court is not going to let you say something that might come back to haunt you later. And I guarantee you, Mr. Zaney is not going to let you say anything that will come back to haunt you later. I've known him many years, and he will not let that happen. But we have this hearing for a reason. You have a right, constitutional right, to know the charges against you. We hear people talk about their First Amendment rights to religion, speech, assembly. We hear people talk about their Second Amendment rights, that famous well-regulated militia. And this is your Sixth Amendment right to the Constitution. It's called the Confrontation Clause, meaning you have a right to confront and challenge any criminal charge brought against you. Okay? So we're going to do 5 things. First, I'm going to read the charges against you with the maximum possible penalties because you have a right to know them. Second, we're going to talk more about your rights. Third, Attorney Zaney is going to ask the court to enter a not guilty plea on your behalf, and the court is going to do that. Then I'm going to give you dates when you return to court. And lastly, Attorney Zaney is going to address the court on bond or bail. The court will make a decision. So first, a point of housekeeping. The address I have for Mr. Workman is in Pennsylvania. Is that the correct address to send correspondence to?
It is, Your Honor.
Okay. So Mr. Workman, anything the court sends you will show up in your old-fashioned U.S. Postal Service mailbox. So please keep an eye on that for things like an order for fingerprints and dates to return to court. The most important thing I can tell you this morning is that you are innocent. You are innocent in the eyes of the law, and you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Wednesday. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. The attorney hasn't seen the evidence. The court hasn't seen it. So you are innocent, remain innocent, unless you plead guilty or are found guilty beyond a reasonable doubt at trial. That said, I'm going to read the charge against you. You are accused of 1 count of operating while intoxicated. This is a violation of Michigan law, MCL 257.6251. This is a misdemeanor, carrying up to 93 days in jail and or $500 in fines. It could also result in your car being immobilized, requirements to attend rehab, some other consequences. And then there's a whole separate Secretary of State proceeding that separate from this court, Attorney Zaney can explain to you. So this is alleged to have occurred on Coolidge Road at or near Abbey Road in the city of East Lansing and on or about August 15th of this year. Now, you have certain rights. You don't just have the right to know the charges against you. You have the right to be represented by counsel. And so you're represented by Attorney Zaney. If you could not afford an attorney, the court would provide one for you. You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence. And you could question any witnesses they brought. You could call witnesses, and if they didn't want to appear, court could issue a subpoena and make them appear. You could bring any evidence you wanted, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, if you had a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. They couldn't be like, well, Workman didn't say much for himself today. I mean, not allowed. You have a right to speak and a right to remain silent. At this point, Attorney Zangi, do you believe Mr. Workman has an understanding of his rights?
Yes, Your Honor.
And how does Mr. Workman wish to plead?
Not guilty, Your Honor.
Thank you. The court accepts and enters that not guilty plea. So next up, we will have the date, and Mr. Workman, you will return to court at 10 a.m. September 26th for a pretrial conference, at 1 p.m. November 8th for a final pretrial conference, and 1 p.m. November 12th for jury selection. Now, please stay in touch with Attorney Zaney because those dates can change. Some of them you need to be here in the courthouse physically. Some you may be able to appear by Zoom, and some Attorney Zaney will handle off stage, as it were. Attorney Zaney, would you like to be heard on bond or bail?
I would, Your Honor, if I may. Thank you. I'd ask the court to enter a PR bond consistent with Court Rule MCR 6.106. As a caveat in this case, the court noted the address. My client resides in Pennsylvania. He was here in Michigan on a contract work. That contract work expires this Friday, at which time he'll be seeking to return back to Pennsylvania. He is a licensed professional in 3 different states, which I think is the driving force, and I think should be the basis for alleviating any concern of his failure to return to court. He has retained counsel and is working diligently to defend against this case. So I would ask the court to grant the PR bond, but allow for the out-of-state travel back to Pennsylvania, at which time, I'm sure he'll be ordered to return to court, will return to court. But I think all other aspects of the standard bond conditions are appropriate.
All right, so Mr. Workman, I'm going to grant your attorney's request for a PR, personal recognizance bond. And that means that I take you at your word you're going to come back. But as I said at the beginning, this is the worst case scenario, right? So if in the worst case scenario, you don't return to court, a bench warrant will be issued for your arrest, and you will have to post $500 to get out. So that's what we call a PR $500 bond. Okay? I am going to grant you permission to leave the state of Michigan to return to your residence in Pennsylvania. Is travel for your work common?
It is, Your Honor.
Okay, so I will grant you permission to travel for the purposes of employment with the understanding that as a condition of your bond, you will remain responsive to this court and also Attorney Zaney and return in person or by Zoom as ordered for all proceedings. All right, number 2, I always feel bad about this because you are presumed innocent, but we tell everyone because forewarned is forearmed, so to speak. So you may not commit any crime while released, but I think you're going to, but you must immediately notify this court in writing of any change of address or telephone number. Attorney Zaney and I were public defenders back in the day. We got ghosted about every 7 minutes. You must also notify your attorney of any change of address or telephone. No ghosting, Mr. Zaney, or the public defenders as they are now. All right. You may not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medications, you are to take all medications as prescribed. Do you have a medical marijuana?
No, Your Honor.
I am going to set up testing, and I want you to contact our probation department By 5 p.m. today, we'll put that email in the chat for you, or you can call them. You can do testing anywhere. So generally, every police station will have a PBT. So I'm going to set up testing because this was an alcohol-related offense. You may not purchase or possess a firearm or the dangerous weapon. You may not use any object as a weapon. You may not engage in any harassing, intimidating, violent, threatening, or stalking behavior toward anyone. I think that'll cover it. Attorney Zaney?
I think that's accurate, Your Honor. We acknowledge those bond conditions.
And I'm signing a fingerprint order. We have the fingerprint order must be done by September 17th at the East Lansing Police Department. When did you say Mr. Workman is planning to leave the state?
September 6th, Your Honor.
Okay, so, well, if we put these in the mail though.
If you could email them to me, I could print off and get him a copy right now so he can get that done this week.
Okay.
Of course, willing to.
Okay, I think the court is more than willing to do that. The other catch is Mr. Workman should call the police department first to make sure that there is someone there who can do the prints.
Yes, Your Honor.
Rather than making a wasted trip. All right, Mr. Workman, a few things. First, this case will be coming back before me, and I sincerely wish you the best of luck as you go through this process. Second, we see a lot of people in this court, generally younger, but in this court, we see a lot of people exactly once for one bad experience. It gets resolved, we never see them again. And that is my wish for you. Lastly, the most important thing you can do for yourself while this case is pending is ask your attorney anytime you have questions. The court is historically based on King of England's court, which is historically based on the Catholic Church. We have certain rituals. We say things in certain ways. They make perfect sense to us because we're here. It might not mean anything to you. More dangerously, it could mean something completely different to you. So whenever you have an attorney, whenever you have a question, ask your attorney. What's a pretrial conference? Ask your attorney. What does that phrase mean? Ask your attorney. Perhaps most importantly, what can I do to help get this case resolved? All right, we will see you back. Best of luck to you, sir. And that is all for this record. Thank you.
Thank you, Your Honor.
Take care, Your Honor. Have a good week.
You too. Bye.
Yeah.
Good morning.
All right, we are on the record in the matter of People versus Damon, Michael Bartlett. Excuse me, this is case 24-0507-OD, and may I have appearances for the record, please?
Yes, Your Honor, Melissa Vachon on behalf of Mr. Bartlett while he appears separately by video.
Thank you. Good morning, Mr. Bartlett. How are you?
Good. How are you?
Fine, thank you. So we are here today for an arraignment, and Mr. Bartlett, I call arraignments the worst case scenario hearing, and here's why. I'm going to read the charges against you with the maximum possible penalty, and you aren't going to be allowed to say anything.
Okay.
The reason for you are presumed innocent, and the court is not going to let you say anything that could come back to haunt you later. Attorney Vachon is certainly not going to do that. So that's why if you try to speak, we shut you down. It's not to be disrespectful. It's not because the case has been decided. It's because it's a whole lot easier to stop you now than to perhaps untangle something.
Okay.
All right. So we are going to do 5 things this morning. First, we're going to read the charges against you with the maximum possible penalties because you have a right to know them. Second, we're going to talk more about your rights. Third, Third, Attorney Vachon is going to ask the court to enter a not guilty plea on your behalf, and the court is going to do that. Then, we're going to give you some dates when you return to court, and those will be mailed to you as well. Lastly, Attorney Vachon is going to speak on your behalf on bond or bail, and the court will make a decision. First, a point of housekeeping. We will mail everything to an address in Charlotte. Is that still accurate, Attorney Vachon?
Yes, Your Honor.
Okay. So, Mr. Bartlett, the most important thing I can tell you this morning is that you are innocent. You are innocent in the eyes of the law, and you remain innocent unless, not unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless because it's different than until. Until means something's going to happen sooner or later, right?
Right.
Unless means we don't know what's going to happen. And in this case, we don't know what's going to happen. You haven't seen the evidence. Attorney Vachon hasn't seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. Now that said, I'm going to read the charge against you. In count 1, you are accused of operating while intoxicated, which is a misdemeanor. With that operating while impaired, which is a misdemeanor violation of Michigan law, MCL 625, section 1. This is a misdemeanor punishable by up to 93 days in jail and or $500 in fines. You could also be, your car could be immobilized, you could be ordered to attend rehab, and then there's a whole separate set of proceedings over at the Michigan Secretary of State's office. Okay? In count 2, you are accused of driving with an expired registration. This is a civil infraction, so that means it's just a ticket you pay like speeding. There is no jail time attached, okay? This is alleged to have occurred on Linden Street at or near Grove in the city of East Lansing on or about August 10th of this year. And this is alleged against the peace and dignity of the people of the state of Michigan. Now, you have certain rights. You have the right to an attorney. And today you are represented by Attorney Vachon. Attorney Vachon, will Mr. Bartlett be applying to your office for representation?
He is, Your Honor.
Okay, thanks. So Mr. Bartlett, if you can't afford an attorney, the court will provide one for you. And I'm especially proud of the superb public defenders we have in this court. Now, you win the Powerball or something and you are suddenly no longer eligible for the public defender. There are also many talented attorneys to hire out in the community. You get to choose the attorney, but you also have to pay them. You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence. And you could question any witness the prosecutor brought. You could call your own witnesses, and if they didn't want to appear, the court could issue a subpoena and make them appear. You could bring any evidence you wanted, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most important, if you had a trial, you could testify on your own behalf, or you could remain silent. And if you remained silent, no one could use that silence against you. They couldn't be like, well, Bartlett didn't say much for himself there. You have a right to speak and a right to remain silent. At this point, Attorney Vachon, do you believe Mr. Bartlett has an understanding of his rights?
Yes, Your Honor.
And how does Mr. Bartlett wish to plead?
Enter a not guilty plea, Your Honor.
Thank you. The court accepts and enters that not guilty. So next up, we have some dates when you return to court. And Mr. Bartlett, you will receive these by mail, old-fashioned postal service mailbox. But I'm also going to tell them to you. You will return to court at 1:30 p.m. September 26th for a pretrial conference. At 1 p.m. November 8th for a final pretrial conference. And 1 p.m. November 12th for a jury selection. Now, please stay in touch with your attorney because these dates can change. Some you might need to be here in the courthouse, others by Zoom, some your attorney will handle off stage, as it were. Attorney Vachon, would you like to be heard on bond or bail?
Yes, Your Honor. I'd request a personal recognizance bond for Mr. Bartlett. He did appear today as ordered. He has a lot of ties to Michigan. He's lived here his whole life. He's working full-time, doing construction. He's also a father. To my knowledge, he has no prior criminal history, so I would request the court grant him a PR bond.
Okay, thank you. The court is going to grant your attorney's request for a personal recognizance bond or PR bond. Means I take you at your word that you're going to return to court.
Okay.
As I said at the beginning, this is a worst case scenario hearing. So if for some reason you do not return to court, the court will issue a bench warrant for your arrest, and then you will have to post $500 to get out. So it's what we call a PR $500 bond. Okay.
Okay.
Going to put some other conditions on it. You may not leave the state of Michigan without prior permission of the court. Now, if you have someplace to go for work, family, for schooling, what have you, we have a form on our website. The attorneys are familiar with them. You must submit that before you leave the state of Michigan. Number two, I always feel bad about this because you are presumed innocent, but again, we tell you up front, you may not commit any crime while released. But I think you're going to.
Yeah.
But we tell you. You must immediately notify this court in writing of any change of address or telephone. You must also notify Attorney Vachon, no ghosting the public defenders. You may not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medication, you must take all medication as prescribed. Do you have a medical marijuana card?
I do not.
Okay, so you may not use marijuana at all. You may not apply for a medical marijuana card without prior permission from the court. I am going to have you set up with testing, alcohol testing, and I'm going to give you until close of business today, which is 4:30 for us, to contact our probation department and set that up. Okay? We'll provide you the address. You may not possess or purchase a firearm or the dangerous weapon. You may not use any object as a weapon. You may not engage in any harassing, intimidating, threatening, or violent stalking behavior toward anyone. I think that will cover it. Attorney Vachon?
Nothing further, Your Honor.
Okay. So, Mr. Bartlett, a few things. First, your case is going to come back before me, and I sincerely wish you the best of luck as you go through the process.
Thank you.
Second, we see a lot of people in this court exactly once for one bad experience, and we never see them again. It gets resolved one way or the other. They go on to their lives, and that is my wish for you.
Mm-hmm.
Lastly, the most important thing you can do for yourself as this case goes on is ask questions anytime you have them. The court is historically based on the Catholic Church. We have certain rituals. We say things, and they mean something to us because we're here every day. Might not mean anything to you. More dangerously, it could mean something completely different. So ask your attorney. What's a pretrial conference? Ask your attorney. What does that phrase mean? Ask your attorney. And perhaps most importantly, what can I do to help move this case forward?
Okay.
All right, well, thank you. Set you up with testing, and I believe that is all for this record.
Court's back in session. Court is now in session. Calling case number 2404588001. People of the state of Michigan versus Richard Londell Cleckley. Defendant is being charged with count 1, assault or assault and battery. Today's the date and time for bond redetermination. Appearances, please.
Thank you, Judge, and good morning. Steve Benson for the people. Please step over 917.
Yes, Your Honor. Brandon Bird on behalf of Richard Cleckley. Mr. Cleckley, can you please state your full name for the record?
Richard Londell Cleckley.
Argument.
56-year-old, lifelong resident of Michigan, Your Honor, lives with his mother. Indicates to us that he's not on probation or parole. Doesn't have any pending cases. Unfortunately, he's on disability. Any amount of bond would be like a remand to my client. My client will be able to afford any amount of bond, Your Honor. Respectfully, we're gonna ask for a personal bond in this matter. He can't afford the $1,000. He understands what no contact means. And
Does your client work?
he's on disability, Your Honor.
Okay. Argument.
Judge, I think what affected Magistrate Ramsey Heat here, and this was one of my arraignments, was the idea that this was just so random in its approach, that these two people didn't know each other. This gal gets off of the bus, she starts walking, he starts assaulting her to the point where apparently, I mean, just based on the allegations, multiple people had to pry this individual off of this gal. So based on the randomness, the defendant's behavior that was completely irrational and no reason for the assault, she ended up issuing the cash. I have one other prior judge, a CSC second degree, person under 13. It was about 30 plus years ago when he was convicted of that. Just wanted to give you just a little bit of background though as to the arraignment. But Judge, I'm going to defer to your greater wisdom when it comes to something like this.
Court haven't heard the arguments of counsel. Court is going to reduce the bond to 10,000 personal with the GPS tether, house arrest, and the no contact provision with the complaining witness. Thank you. Did they have any other ones, or are they still doing one at a time?
One at a time.
Okay. All right.
Yeah, I think one of them, Judge Marcy and I heard that they were actually waiting at Judge Bryan's courtroom for a tether violation.
And who was that?
David Payman.
Who was it?
David Payman.
Call the case.
Calling case number 2404588301, the people of the state of Michigan versus David Payman. Defendant is being charged with count 1, retail fraud, second offense. Today's the date and time for bond redetermination. Appearances, please.
Thank you, Judge Stevenson, for the.
Yes, Your Honor. Brandon Byrd on behalf of David Payman, in which my client isn't here.
Okay. Do you wish to waive your client's appearance or adjourn this until tomorrow at 9 a.m.?
We could waive his presence on this one, Your Honor.
Okay, presence will be waived. Argument.
One moment, Your Honor. I am familiar with Mr. Payman, Your Honor. I do understand he has multiple cases with our office. This is being charged as a misdemeanor. Not to take away from the severity of any crime, because but it is being charged as a misdemeanor, and respectfully, we're going to ask for Mr. Payman to be released on a personal bond if he's able to be released from Judge Bryan.
Prosecute.
Judge, with due respect to defense counsel, multiple cases is probably the understatement of the morning. He has 17 ongoing cases. He hasn't listened to his counsel that are all very well adapted and smart at what they do. He's on tether at the time when he allegedly ends up committing this crime. He's on bond at the time. He has great counsel. Apparently it doesn't matter to him, and he's on probation.
Bond continues.
One thing about this, Your Honor, and this just, I understand that he indicates that he's not on medication and mental issues, but I have had my experience with Mr. Payman, and I'm not sure if we can mark his file medical, or where he might could get a psych evaluation or some sort of treatment while he's in the county jail. But
The file will be marked medical, and the reason for the continuing of the bond is flight. It's It's a danger, but not as in a physical danger, but it's a danger that these type of property crimes are going to keep being committed. And it's that type of danger. It's not a physical danger, but it's a danger to all the businesses and establishments that he keeps getting charged with. All right, thank you. All right. So we have Alexander, Flemings, Sawyer. All right. Text when you get one. Be like, that's again.
Court is now in session. Calling case number 24055484001. People of the state of Michigan versus Davon William Sawyer. Defendant is being charged with count 1, stolen property, receiving and concealing motor vehicle. Felony, commission of a motor vehicle advisory, today's date and time. Provide redetermination appearances, please.
Thank you, Judge Stevenson, for the people. Please don't roll.
Yes, Your Honor. Brandon Bird on behalf of Devon Sawyer. Mr. Sawyer, can you please state your full name for the record?
Devon William Sawyer.
Current bond is 30,000. Argument.
Yes, Your Honor. 20 years ago, lifelong resident, lives with his mother and siblings. Indicates to us that he's not on probation or parole. I do believe he might have came in on a pending case, to be forthcoming. If I could just ask Brother Counsel, am I correct with that?
Yes, the RCSP motor vehicles as well as a fleet.
So he did come in on a previous case. On a pending matter, receiving and concealing stolen motor vehicle with a fleeing, Your Honor. Respectfully, though, we're going to ask for a personal bond in this matter. He does lawn service from 8 a.m. to 5 p.m. Monday through Friday, and he indicates to us that he didn't get a court date or any papers from the jail when he was released last time. And I'm pretty sure our office had a thorough discussion with him about he's going to hear his court date right now. It's his responsibility to keep up his court dates. And I know one place that he probably doesn't want to be is sitting in that room he is right now. So respectfully, we're going to ask this court for a personal bond on these non-assaultive allegations, Your Honor.
Argument, Mr. Prosecutor.
Judge, Mr. Bird is good at what he does, and this doesn't go against him, but to the defendant, a little disingenuous when he tells defense counsel he didn't know about the court date. He's been through this before. He's young, he has priors, he has an April 19th A and B juvenile adjudication. He has an October 20th RCSP motor vehicles, same as what we have here. He has a November of 22 felony R&O that was deferred under HIDA, and we believe that he's still on probation for that. So while he has the most recent R&O deferral, and while he ends up not voluntarily coming into court to take care of this matter, which he failed to appear about 7 months ago, he ends up picking up, not a pen, he ends up picking up this same alleged set of particulars, same charges. But now we have a fleeing too. So, Judge, we're going to leave it up to you. I know that 30,000 was set by Judge Giles, but I don't know what else you can do when you have somebody who's out on a warrant for failing to appear, picks up the same kind of case, and it appears as though he's on probation for a felony R&O. that he got the chance under HIDA. Judge, we're gonna leave this up.
Mr. Burt, final word?
I do understand the prosecutor's concerns and what might be this court's concerns, Your Honor, but respectfully, my client, as is wise and honorable court understands, my client's still innocent unless proven guilty beyond a reasonable doubt. I do understand he has some juvenile adjudications. I don't have anything to believe that my client knew about the court date, even though he's been through this before, because we're dealing with this situation. But I do know going forward that my client understands that he's gonna have to show up to court, and if these cases keep piling up, if he is found guilty, he's gonna do prison time. And I'm pretty sure that's not where a 20-year-old wants to be.
All right, court, I haven't heard the arguments of counsel. Court is very concerned that Mr. Sawyer keeps finding himself charged with the same offense and then not coming to court. He doesn't seem to even mix it up a little bit. It's not a random, narcotics charge or gun charge. They're all stolen cars, it seems like. And now we had a little fleeing element. It is nonviolent. So the court is going to take that into account, and we're going to take his age into account. So we're going to try this one more time. So we're going to go with a 30,000 personal, but this time we're going to go to GPS tether, house arrest. He's not to leave for any reason except for court appearances. And I don't need to say no driving because he's not, no driving. Don't even drive to court. That is your only time you can be out. If there are any violations, this will be converted to 30,000 cash. All right, thank you.
You're all set, sir.
I've got to go soon, just a heads up.
As to
Yes, Madam Clerk.
Mr. Alexander, it's my understanding they're not bringing him out. They're doing something with a tablet. Do you have any information on that? I don't know how that's going to go.
I don't, Your Honor.
I'm just calling the next one. She said they were taking it to his pod. Yeah.
So are we going to have him anytime soon, or should we
This is from where he was to his pod.
Okay. And nothing on Fleming's.
She said
I'm willing to go with whatever it is, wise and honorable court. Dude.
Yeah, we went to that circle. She was giving me a circle. I don't know what she said.
Yeah.
Ridiculous, but we
Some opportunity for. So Judge, we got into it, but we didn't get into it. So, I mean, was there still some opportunity for good family time down there? Like,
Yeah. We did. It was like I said, that was quite annoying and ridiculous, but we did. But I've got somebody.
Okay.
That must be
Donna, this is Dante Alexander.
Oh, switched it up on us.
11501. Defendant is being charged with count 1 and 2 and 3, criminal sexual conduct, second degree relationship. Today is the date and time for bond redetermination appearances, please.
Thank you, Judge Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Dante Alexander. Mr. Alexander, can you please state your full name for the record?
Dante LeBron Alexander.
Bond is 100,000 cash. Argument.
48-year-old lifelong resident of Michigan, Your Honor. Indicates to us he has 3 children, which nothing's been provided that there's been any CPS cases against those children or any allegations set by those set against them with those children. Lives with his wife and kids. States to us that he's not on probation or parole, doesn't have any pending cases. He indicates that he's an independent contractor who makes well below the 200% poverty guidelines. Any amount of bond is going to be like a remand for my client. Now, he's on 4 different medications, Your Honor. We can mark his file medical to be appreciated. I do understand the egregious nature of these allegations, and I do have a respect for the egregious nature of these allegations, but I also have a respect for the crux of this justice system, is which innocence beyond the reason, unless proven guilty beyond a reasonable doubt. And my client's looking forward to his day in court in this matter, and respectfully, we're gonna ask this court potentially for a personal bond. If the court's not inclined to a personal bond, then a reasonable or low 10% bond seems fit by the court.
Mr. Prosecutor.
Judge, relationship being this defendant's stepdaughter, one of the children that he lives with, that the defense counsel had just told you about, allegedly grabbing his stepdaughter's breasts on different occasions, as young as when she was 12, putting his hand over her private lower area. Clayton's father was actually charged. He had an arraignment the morning that this defendant had an arraignment. In the afternoon, that individual, the biological father, had an arraignment in the morning time. Allegedly, what happened was the complainant ended up calling. Well, first, she ends up telling her mom, who she lives with. Mom doesn't believe her. So she calls her sister, who lives with her biological father. Father ends up calling the police. Then he drives over to this gentleman's house after he heard about the allegations. He allegedly assaulted this individual. I don't know if the people are buying into that, but this defendant's lucky he didn't die based on the alleged allegations of what the father ended up doing to this defendant. Now, here's the telling part. That father ended up getting a personal bond that morning, but it's this defendant who ended up getting the 100,000 cash as a direct result of what the magistrate felt was appropriate due to the actions of this defendant. I mean, at most, this gal was 14 years old. At her earliest, she was about 11 years old. And we're talking about substantial inappropriate behavior. So respectfully, Judge, we're asking you to continue.
Continues based on the court finding that the defendant is a danger to the community as well as the complaining witness. Let me see it.
I can do the whole file.
Whatever, just something I can look at. Yeah. All right. You're good to go, Mr. Alexander.
What's our next court date, Judge?
Madam Clerk.
With Judge King. September sixth at 8:30 with Judge King.
That means Judge King will be back September 6th.
Thank you, Madam Clerk.
So are you guys gonna bring Clemens, Lamont?
I don't have anyone else on this camera right now, so I'll be signing out and my team will be signing in.
Okay, thank you.
Yes, ma'am.
Okay, that's a good time for me to sign out as well because I have to leave for dancing soon. The interesting thing is that means that Judge King will be back September 6th, which is in 3 days' time. They've now disabled the chat. People were asking, saying, I thought the judge was supposed to be back, etc. Okay, I probably won't see you later. I'm redirecting you to Broken Baker. I'm hoping that I haven't timed it, that he's already done. But he is doing Sarah Boone's motion hearing. So let's head there. I lost about 30-ish people in the last 15 minutes. So it's a 10-person raid, but we'll do it. Doesn't matter. Let's head over.